Oh, okay. We're in privacy mode. Testing. One, two, three, 4, 5, 6, 7, 8. Okay. Okay. So now, how do I turn that off? It's not,
Just hit, you could hit.
but it's red. It was green. It's supposed to be red to go. I mean,
state law. It's fulfilling the requirements of AB 2792.
which is called the Transparent Review of Unjust Transfers and Holds, the Truth Act. And it's primarily for for you to hear reports from the sheriff and probation department. We also have an attorney who's going to be giving kind of an overview. And it's so it's really for transparency and to give you a chance to comment to us on how on these reports. So you're going to hear these reports, and then you'll be allowed to speak. So we're going to be providing information on ICE access to individuals provided by Alameda County law enforcement agencies for the calendar year 2017. So this is not, but we're going back to 2017 this year. And okay, so the point is that you can come away with a better understanding of what law enforcement is doing in the community. So I did want to mention before we start that the Board of Supervisors has passed 3 resolutions related to this topic. In 2013, prior to the one of the acts, not the Truth Act, the other one. Yeah. So in 2013, we passed a resolution, and you can look that up. It's in the county notes, calling on the sheriff not to comply with ICE requests. We were told at that time that we could not control the way the sheriff chose to run the jail, but we did pass a resolution during that time, prior to that that period. And then in 2016, we passed another resolution which sharpened our opinion, and it was about due process. And again, asking the Sheriff's Department not to cooperate with ICE. And in 2017, we passed a resolution naming Alameda County as a welcoming county, which is basically very similar to sanctuary city resolutions that other cities have passed. And again, reiterated what the Board of Supervisors' position was regarding the sheriff's cooperation with ICE. So just to let you know, besides the acts that are going to be talked about today and the changes that have happened, I just wanted to let you know what the board's position had been over the past several years. So we're going to start with the sheriff's report. And one last thing before we start. I do want to let you know that we did receive some questions from the California Immigrant Youth Justice Alliance, and I believe you can come up and talk about those, but I believe that almost all the when I looked at the presentations, all the questions should be answered in there. You may not absolutely love the answers, but all the answers will be provided to you. Okay, Sheriff Ahern.
All right, good afternoon. We have somebody, thank you. So the Assembly Bill number 2792 by BONTA, Local Law Enforcement Agencies, Federal Immigration Policy Enforcement in regards to ICE access. Beginning in January 2018, local governing body of any county, city, or city and county in which the local law enforcement agency has provided ICE access to an individual during the last year shall hold at least one community forum during the following year. The reason that we're here today. Local law enforcement agency may provide governing body with data as it maintains regarding the number and demographic characteristics of individuals whom the agency has provided ICE access, the date access was provided, and whether ICE access was provided through a hold, transfer, or notification request, or through other means. And data may be provided in the form of statistics, or statistics are not maintained individual records. So we've done our best to keep a very thorough record of our processes. ICE access means for the purpose of civil immigration enforcement, including when an individual is stopped with or without their consent, arrested, detained, or otherwise under the control of local law enforcement, all of the following must occur. Responding to an ICE hold notification transfer is item number 1. Providing notification to ICE in advance of public that an individual is being or will be released at a certain date and time through data sharing or otherwise is number 2. Providing ICE non-publicly available information regarding release dates is number 3. Allowing ICE to interview an individual is number 4. And providing ICE regarding dates and times of probation or parole check-ins. We have a general order that covers our policies and procedures, and it's made available to people upon request. Under no circumstances shall a person be detained or arrested by the Sheriff's Office members based solely on his or her immigration status, whether known or unknown. Our general order also precludes us from asking immigration status, and we do not track citizenship or immigration status, and our agency, as well as the other local law enforcement partners, do not do any frontline immigration enforcement. California Penal Code 13150 is how the immigration enforcement officers learn of the people that are in our custody. By law, California law, we're required to take fingerprints and provide information to the Department of Justice. That information that we provide under 13125 includes personal identification data, arrest data, misdemeanor or infractions, preliminary hearing dates, superior court data, and corrections data. To the right on the form, you'll see the other information that we require and gets forwarded to Department of Justice. The I-247A form is generated from that information that we provide. So what happens in Alameda County, the state of California, and throughout the United States is an individual who is in our country undocumented and gets arrested, gets fingerprinted. The Federal Department of Justice has no idea who the individual is. That information goes to their immigration enforcement people, and it's retained based on country of origin. The second time an individual is arrested, brought into custody, is fingerprinted again, and then that information goes to the immigration officials, and they suspect that that person is undocumented. They put an immigration detainer notice of action. It's called an I-247A form. That then gets sent to our jails via a fax machine. That fax machine gets those both at San Rita Jail and Glendyre Jail. That's considered access, right? So the 1 through 5 items that I spoke about earlier, responding to ICE hold notification or transfers. In 2017, we have a different policy than we now do in 2018 because of SB 54, and I'll explain that. So number of access, there's 405 access at San Rita Jail that fall into ICE notifications. Number 2, we're providing notification to ICE in advance of or will be released at a certain date or time through data. You see the last bullet on there has a total of 1 and 2s for 200 to 1. That means that the time we received the I-247A form, we immediately responded to that request and notified them of their release date, and an advice of counsel calculated those numbers to be 200 to 1 events. Immediately following that, their information was made available to the public. However, it could be determined that we notified ICE in advance. Well, in advance of a few minutes in most cases. Item number 3, providing ICE non-publicly available information in regards to personal information, address, work addresses, computer database, jail logs, etc., is 0. And allowing ICE to interview individuals, that falls underneath the Truth Act, and that's 0. And providing ICE information regarding probation or parole check-ins, that also is 0. So from Santa Rita Jail, ICE came to our facility and removed 353 people. Those stats are broken down into race, into age, into notification request, and how we responded, and the total incidence of access. It's 815. That's not 815 different individuals. That's 815 times of access. They could have asked for access to an individual 2 or 3 times, and that would still be included as access. We track each time they do that. We do the same for Glendyre Jail, and you see the numbers are much lower because the capacity there isn't as large as Santa Rita Jail. In 2017, under those same conditions, 33 individuals were picked up by ICE. Those individuals are broken down in the same data categories as you see from Santa Rita Jail. So the total number of events at both jails, D&C stands for Detention and Corrections, were 509 were ICE notifications from the I-247s, and that information resulted in a total of 386. That's the combined total of both jails. Here's the data of those individuals. And you see again, it's 966 times of access, but it's not 966 individuals. Here we gave you some historic breakdown on how this all came about. In regards to the years, you see the numbers fluctuate. Numbers fluctuate based on the laws that have been recently passed. So in 2008, there was a program called Secure Communities, and 14 jurisdictions across the county were under the program of Secure Communities. In 2010, we began recording the number of events at our jails, and we had 347 events. Under Secure Communities, immigration enforcement officers would come to Santa Rita Jail and Glendyre Jail every day about 5 o'clock in the morning. And they'd go through our arrest records and determine if they wanted to speak to an individual in regards to their status. In 2011, you see the number increased. That was under President Obama's administration. He expanded Secure Communities activities in regards to terrorism, is what we believe. In 2012, there was a continued dramatically increase, and it went up to 768. And again, in 2013, reached a high of 908 requests. Then, under the Clackamas County court decision, came into effect at the same time the Trust Act did, which was AB 4. And under the Clackamas County, it was ruled a constitutional violation of the Fourth Amendment if we detained an individual after their release date. So from 2010 to 2013, we held people until ICE came. We gave them 48 hours to come and take custody of the person in jail. If they didn't show up within that 48 hours, the individuals were released. After Clackamas County in 2014, we changed our policy to hold no one after their assigned release date. That caused the numbers to drop down from 908 to 588. In 2015, it also dropped down, as you can see. In 2016, it increased. And in 2017, the Trust Act came into effect. And the first part of the year, there was no activity, very little. Then the immigration enforcement officers began to increase their activities after April. And after April, the numbers went all the way up to 731. In 2018, with the passing of SB 54, those numbers have decreased almost in half, and the number of individuals has decreased greatly. ICE no longer comes into our facilities on a daily basis. They're hardly in our facility. They come into Santa Rita maybe 2-3 times a month now, and the last time they were in Glendower Jail was June of this year. And those are estimates from my staff doing some research. So with 2018 and SB 54 and the Truth Act, request for notification for an individual has to meet the following criteria. They have to be serious or violent felons listed under 1192.7 or 667.5C of the Penal Code. The individual has been convicted of a felony punishable by imprisonment in state prison, and that's a reference to AB 109 and the number of people not sentenced to state prison that are in custody at local facilities. So that's another requirement that has to be punishable by state prison. And an individual could be qualified under SB 54 if they're a current registrant under the California Sex and Arson Registry. Next, the individual is arrested for a serious felony or violent felony as identified in the previous penal codes, or a felony that is punishable by imprisonment in state prison, and after appearing before a magistrate. So they have to have the preliminary hearing before they can be in compliance with SB 54. There's still some argument in regards to what exactly is that preliminary hearing and what are the qualifications of that. The individual has been convicted within the past 5 years of a misdemeanor for a crime that is punishable as either a misdemeanor or a felony. So that terminology in our world is called a wobbler, or has been convicted within the last 15 years of a felony as described in 7282.5 of the Government Code. So under SB 54, we continue to comply with the Trust Act, which is AB 4, and the Truth Act, which is what we're talking about today, AB 2792, passed in 2016. We also follow the California Values Act, which is SB 54, which came effective January 1. SB 54 sets specific criteria as previously discussed for law enforcement agencies when corresponding with ICE. So even though ICE send us those I-247A forms, that doesn't necessarily mean we have any response to them whatsoever. They have to be in compliance with the SB 54. In 2017, prior to the implementation of SB 54, we received 731 I-27 forms, and ICE took custody of 386 individuals. As of September 27th, they filed 470 247A forms, and they've taken 86 individuals into custody. Those individuals that they've taken into custody from our jails are violent felons that have been arrested or convicted of crimes of assault with a deadly weapon, rape, murder, sexual assault, child abuse, and murder. Take any questions you might have.
Okay, we're going to do the speakers at the end of all three presentations, but let me just, for the record, ask these questions we got in writing. It says the ones that you haven't answered. What is your process for releasing a person from custody, and how long does it usually take?
Depends on the initial crime and where they're being housed. So if someone is brought in on a misdemeanor, most likely they're released within 4-6 hours if there's no problems in regards to their level of intoxication or outstanding warrants. For the most part, we get people in custody that aren't going to be housed. They're out of our custody within 12 hours. If they're housed and in custody, depends on their status. If they're a highly secured inmate, we have to wait till we have 2 deputies that can escort them to the intake, transfer, and release section and release them. The minute we find out someone has authorization to be released, either from a court proceeding or a DA not filing their charge, they're immediately brought to the release section, regardless of the time of day.
Okay, and then who from the sheriff's office is responsible for notifying ICE, or how does the process work? And then how far in advance does ICE know when a person will be released?
The I-247A forms get brought into our records section at the jails. At both jails, we have a records deputy. A records deputy receives those notifications and first determines if we have the person in custody. Many of the access forms you see there are for individuals that either have not ever been in our custody or have been released from our custody because it was a misdemeanor arrest and we did not hold them. So a records officer reviews those forms. Then that process is also then determined to be if it falls within compliance of SB 54. If it falls within the compliance of SB 54, we make a attachment of that request form to the jail jacket. We don't notify ICE of release dates. It's incumbent upon ICE to determine the date and time of an individual's release. I want to make sure, where's Madigan? Where you know better. Sheldon, I'm good? Okay.
Okay, and then why does the sheriff's office post release dates for people in custody?
We post those dates for a number of reasons. One, your board in 2012 asked us to be more transparent in regards to release dates. So we created a program well before SB 54, well before immigration. I believe Supervisor Carson was on the board when we started the VINE program. The VINE program is victim information notification efforts where we can notify victims of specific crimes. Used to go to their house phone when people had house phones, and it would automatically call their house every 30 minutes until they made a positive comment on the phone as if, hello, be advised this person is going to be released for their safety. The person opted in for VINE. We were the first county in the state of California to be a part of the VINE program. The VINE program and our inmate locator are some of the new technologies that we have in place that make our jail more efficient. So we've contracted with companies to allow us records management system so we know one-stop shopping about individuals, what they're in custody for, how much money is on their books, when their release date is, and do they have any outstanding ones. So it's all a matter of an application. It has nothing to do with ICE.
Okay, and the last one, you answered part of this already. I guess people want to know the ones who ended up being picked up by ICE. It was 86 this year, whatever. Do they come? I mean, how does it usually go? Do they come right away, or just generally what happens?
They know when the individual's going to be released. They look at the inmate locator and have access to those release dates just like you would or any member of the public. By law, those are public records, and ICE is made aware of their, simply by their doing the research. So what typically happens is local agencies arrest somebody for a violation. They go to court. They get a release date assigned to them. Then ICE will know that date because they're checking. When they find out that release date, they come during that date and time to take custody of that individual. We don't hold them for not 1 minute past their release time. If ICE is there, they take them into custody. If they're not there, they're released. Each and every inmate's treated exactly the same, regardless of their immigration status.
So the ICE agents, they wait outside of the jail till the person comes out? And I guess people want to know the
There's
process?
2 locations, well, 3 locations. They can wait outside either one of the jails or come to the area where the inmate is processed and provided their property and clothing. So when we release people from our custody, we don't release them in our jail clothing. We retain our jail clothing and we give the inmate back their clothing the day they were taken into custody or clothing that was brought to them for their release date. They also, for the most part, have a property bag. That property bag is then issued to them. They sign out for their clothing and their property, and then that's the time that ICE can take them and take them into custody. Just like we would OPD, FBI, any other local agency.
Okay, there may be some other questions later. Supervisor Miley.
Thanks, Sheriff. A few questions that I have. Now, the law that you're reporting on is a state law.
Correct.
And does the law apply to just sheriff's departments, or does it apply to sheriff and local law enforcement like OPD? And
I'm not the attorney, but I believe it applies to anybody that allows ICE to have access to a person that they've detained with or without their consent and have them in custody, and provides access to ICE.
so the point is, so this could be any law enforcement entity in the state of California, just California.
For the most part, it's cities that have a city jail, like Fremont, Alameda, et cetera,
Okay.
Berkeley.
And so we'll get and this is the first year of the hearing, so we'll get data as a result of all these hearings. Do you know what's going to happen with the data? Is it going to be compiled statewide into a record or something?
No, I don't.
You don't know? Because I'm looking, and this is just for California, so that there's not similar data that's being compiled across the country. This is just in this state.
In regards to
This
the
type
Truth
of
Act,
thing.
yes.
Because I'm looking at the demographics, and a lot of the demographics seem to be Hispanic males. Can you kind of speak to that? Why is that such a large demographic?
We take a lot of individuals into custody. I don't know how ICE goes about doing their job and effecting arrest.
But does that have anything to do with ICE, or does it? Because I'm just looking at the Truth Act demographics, and generally it's Hispanic males type of person.
Since 1980, for the most part, ICE in this area has focused on Hispanics.
But you have no indication why that demographic is so huge.
I don't.
Okay. All right. Because I'm just trying to get a sense of how this would look across the state in terms of the demographics as well. That's why I'm hoping that as a result of these hearings, we'll have other data so we can formulate appropriate laws and policies and guidance relative to the data that's being gathered. And then, it's California, but then there's the whole country as well. But if similar demographics and information isn't being provided across the country, then it's going to be hard to try to look at anything nationally. But at least we'll be able to look at it in this state. But at the moment, this is what we have. And you can't read anything between the lines here. Okay.
Other questions before we do the Supervisor Pine?
Is there a question? Your light's on.
Yes, sir.
Okay.
Is there any difference in the general processing of a person that's coming out of jail who has an ICE hold versus anybody else?
No. All the inmates are treated exactly the same
So
in regards to their specific classification.
Okay. So you said it takes between 4 to 6 hours and sometimes as long as 12 hours?
It depends. We process anywhere between 80 to 100 people in our booking facilities each day. And if there's fewer number to be processed, it goes quicker. If it's a busy day, then it might take longer. For the most part, you're out of custody within about 6 hours.
Does Does ICE ever request information about a person's place of birth
Yes.
and and their citizenship as well?
We never ask citizenship.
Okay.
We do ask place of birth to know if somebody's born in Oakland, California, Missouri, Texas.
And that's part of your intake questionnaire when they come in?
Part of the law that I put up on the screen there.
Yeah.
Department of Justice information.
Okay. And how does your department, let me read this. How does the Alameda County Sheriff's Department keep track of whether individuals with ICE holds who are not protected by SB 54 are released no later than they would otherwise be released if they didn't have an I-247 request?
All right, we have a records deputy that is responsible for the release times, and we have a sergeant assigned to intake, transfer, and release. They have a list of people to be released, and they process them throughout the jail wide. And as they come in, the deputy and the supervisor have to validate the fact that the person isn't going to be held on that charge that they were in custody on, and there aren't any other charges. And it's not as easy as one might think. And then you have to make sure the person doesn't have any outstanding warrants.
The sheet that shows the data from 2010 to 2018 and
Yes,
the
sir.
indicators of total requests received and then people taken into custody. There was a surge in 2017 that was 386.
Yes,
And then recently from January through the end of September, let's say, there was 86. Do you have any idea why the reduction?
right. Because of the Truth Act and SB 54, immigration officials don't get to come in and talk to a person that's in custody unless that person agrees to that interview. And two things occurred. ICE doesn't fill out those forms to make the request to speak to the inmate. And I believe the one time they did, the inmate declined to talk to him. Am I one time? Yeah. I think we have one of those requests. And that falls under the Truth Act. So they're basically not very good time spent by immigration officers coming to the jail. They're not allowed contact with the inmates.
So it looks like the intent of the legislation has reduced the number of people that ICE is detaining.
Correct.
And as a result, we're seeing less presence in Alameda County
A great,
of ICE in the
yes.
jail?
They used to be at our jail every day, both jails, at 5 o'clock in the morning. Now, maybe twice a month. They come to Santa Rita. They haven't been, to my knowledge, to Glendire Jail since June. It's just ineffective for them to show up at the jail.
And as Supervisor Miley stated earlier, through these hearings, we're beginning to gather more information. Now, all of your data, where is it being recorded in Sacramento? Where do you submit this to?
I submit it to you. I don't
Okay,
submit it to
and we
Sacramento.
do we submit it to, Donna, do we submit it to the state?
No.
So is there a central depository for all this information statewide?
My obligation is to report to you.
Okay.
That's what I'm doing.
So Donna,
it was the
doesn't the
bill.
law provide
You didn't put
for
it in.
notifications to the state of California, and if so, to which office?
So under this particular act, under the Truth Act?
Yeah.
Not
Well,
that-
all of this data, the data that the sheriff has just shared with us, where is it going from here?
So my understanding is that the purpose of the forum is to put it out publicly, and that it's not going anywhere
Okay,
from here. But
Okay.
we can double check that.
okay.
But
I was just informed that while this bill didn't have a reporting mechanism, SB 54 has a reporting mechanism to the Attorney General.
Okay. All right, because I'm wondering if the trend that we're seeing, if Los Angeles County, if, Fresno County, Kings County, and others are seeing similar kinds of reductions as well.
I'm sure if enough Board of Supervisors request the state sheriff's, more than happy to compile the information that they have.
Okay,
The difficulty you'll have is not everybody does the same data categories as we do.
all right,
They do different ones than we do. These are the ones we selected.
okay. Thank you, Sheriff.
Other questions for the sheriff? Otherwise, we're going to.
And Supervisor
Chief
Valle.
Still.
Oh, I was going to say Supervisor Valle, I'm having my staff look it up right now, but SB 54 does have a reporting requirement. We're double checking when that reporting requirement starts.
Thank you.
And it may not be the exact same information that you just received.
Good afternoon, President Chan and supervisors. Wendy Steele, Chief Probation Officer. Thank you. It's a pleasure to be before you today to speak on this important topic. In terms of Alameda County Probation Department's immigration overview and goals is our goal is to ensure our staff are well informed on departmental immigration policies and all the applicable legislation to follow state, local, and federal law without placing undue burden on our immigrant clients and community, and fulfill our data reporting obligations to our recognized local authority, which for probation is the Board of Supervisors. I'm going to walk through the presentation, the different impacts of the pieces of legislation that have affected probation. First, I'll start off by saying that probation has never reported any information regarding juveniles because of the confidentiality requirements surrounding juvenile detention and also supervision. We've never reported on that, so we've been in compliance with the law since day one. In January 2014, AB4, the Trust Act, was passed. In January 2015, the SB bill was passed. In September 2016, the original Truth Act was signed into law. And then also the Board of Supervisors resolution upholding due process and protecting civil rights of the immigrant residents resolution was signed. In January of 2017, there was AB 2792, which enacted additional pieces to the Truth Act. And then in January 2018, SB 54 California, the Values Act, and AB 2792 Truth Act clause were enacted. I'm going to quickly go through each one of the pieces of legislation. The Trust Act, initially, the transparency and responsibility using state tools, which was Assembly Bill 4. It was effective January 1st, 2014, and that particular act prohibits a law enforcement official from detaining an individual on the basis of an ICE hold or after that individual becomes eligible for release from custody. The Human Services Senate Bill 873, that was enacted and became effective January 1st, 2015. And that grants superior courts the jurisdiction and creates an affirmative responsibility to make the findings necessary to grant undocumented minors special immigrant juvenile status when there's evidence to support the findings. And special immigrant juvenile status gives undocumented minors residency when they cannot reunify with legal guardians due to abuse, neglect, or abandonment. We've never experienced that situation in Alameda County. The BOS Resolution 2016-274, the Upholding Due Process and Protecting Civil Rights of Immigrant Residents, that, as you know, was passed and adopted in September of 2016. And its purpose was to uphold due process and protect the civil rights of immigrant residents. The Truth Act, again, the transparent review of unjust transfers and hold, Assembly Bill 2792, that was signed into law in September of 2016 and became effective in January of 2017. And for probation and the impact, it sets certain obligations on California law enforcement agencies if they provide information to ICE. In brief, upon receiving any ICE hold, notification, or transfer request, the law enforcement agency must provide a copy of the request to the individual subject to the ICE hold. Probation has never received an ICE hold and has never responded to one. Further, if ICE wants to interview a subject, the subject has the right to refuse the interview or must sign a consent form to participate in an ICE interview. Effective January 1, 2018, the Truth Act requires any local governing body, including the county, that has provided ICE access to an individual during the last year to hold at least one public community forum during the following year, which is this forum. Senate Bill 54, the law enforcement data sharing, that became effective January 1 of 2018. It prohibits law enforcement from investigating, detaining, arresting, or assisting in any immigration enforcement activity, and it also eliminates the requirement the local law enforcement inform ICE of certain arrests for specified control substance provision. So in terms of the Probation Department's immigration policy and or protocol timeframe, in January 2014, the Trust Act again went into effect, and ACPD has never had a policy directing staff to cooperate with ICE or hold youth on ICE detainers. In July 2017, adult investigation staff were advised they were no longer to required to inquire about a defendant's immigration status as part of the report and sentence investigation. And those reports, of course, go to the court. August 2017, investigation staff were further informed that the questions regarding immigration were removed completely from the report and sentence template. And then in February 2018, the department finalized the revised immigration policies for our adult field services and sent the policy to labor. In March and April 2018, Teamsters and ACMEA were notified that the department notified the union relative to our immigration policy changes. Also in April of 2018, I did a personal video message to our staff informing them of the current law provisions and departmental policy. And then in May of 2018, we publicized the final policies for the adult and juvenile field services, putting out another SnapCon video to all staff, and in June of 2018, publication of the finalized policies for juvenile facilities. So as of May and June 2018, we had formally not only revised departmental policy, but negotiated with the unions on our policies. And in terms of the adult field services policy, as we stand right now, staff is not to inquire as to the client's citizenship or immigration status as part of a court report, pre-sentence and investigation report, or under any other circumstances. Also, staff does not provide California law enforcement, telecommunication, or CLETS information to federal immigration authorities. Staff shall continue to not include information in any court report regarding a client's immigration status. And to reiterate, this change took place in mid-2017. Staff is to consult with their unit supervisor if they are contacted by any U.S. ICE requesting information, and staff will not provide the information to ICE. If they are contracted, the unit supervisor is to consult with the division director, and each matter would be addressed on an individual basis. In short, for the juvenile field services and facility policy, we have never cooperated with ICE, we've never provided any information to ICE, and we will never provide any information to ICE regarding any juvenile. In terms of the adult field services instruction and survey of ICE contacts, in April of 2018, all of our deputy probation officers were notified to forward any immigration authority contact information covering the period of January 2017 through March 2018 to the Deputy Chief Probation Officer. And that included any hold, notification, transfer request received from ICE or U.S. CBP, Customs and Border Protection, as well as any other immigration authority. We requested the name and PFN of individuals whom ICE was provided access, if existed, and the date the information was provided, and whether ICE access was provided through a hold, transfer, or notification request or any other means. And this was basically our effort to collect the information that's required for us to report here today. The results of the Adult Field Services Survey indicated that ICE contacted probation on 18 individuals in 2017, and of those individuals, only 3 were active to probation. The total number of ICE requests for dates and times of probation check-ins, we received 0, and of course, therefore reported 0. And of the 3 individuals that ICE did contact that were active at that time of probation clients, The 2 requests were for booking information and probation status, and 1 request was for the last known address. And updating on those 3 individuals, 2 of the individuals successfully completed probation supervision, and 1 of those individuals continues to be under our supervision. Juvenile instructions, again, they very much mirrored the adult. However, we've never reported, never going to report. We surveyed, and they had not received any contacts. Thank you very much. If there are any questions.
Questions? Supervisor Valle?
Actually, this question is to the chief and to. I understand that there's been no contact with ICE, but if there was, is there a form that you have that gives the person their rights and they can check a box? I think I've seen that in the legislation where they say, I agree to speak with ICE or do not, or deny.
We do not, we've never received a contact from ICE regarding that. If in fact we did, we would notify them. But our policy is to not interact with ICE and to not give ICE any information. So we would not be providing ICE with any information relative to an interview.
So Sheriff, in your department, how is a person notified that they have the right to
We do a
deny
lot of
or-
notification. There's a form.
Okay.
This is a small version of it. The inmate is given a copy of the form saying ICE has made an inquiry to you. We then have the form attached to their jacket. We then have the form processed and sent to their attorney of record, and we retain a file of that. And no inmate has ever gone through and asked to have the interview. So there's boxes that they check, and it's each time they want to talk to you about any case. So they're provided a document.
One more question that I wanted to ask, and that is, how do you keep track of the people who have the ICE hold and whether or not they get released on a timely basis versus other people? How do you keep track of that who don't have ICE holds?
Right. So there's no difference if a person had an ICE hold or didn't have an ICE hold. They get processed for release just like every other inmate. So there's a list of inmates scheduled for release. Picture the jail, 18 different housing units, 1.5 miles in circumference. We send deputies to the different housing units to walk the people back to the intake, transfer, and release. There's a phone call made to the house where the inmate was being held. They said, hey, prepare Johnny for release. Johnny packs his stuff. Sometimes Johnny can pack really quickly. Sometimes it takes him a while. As soon as he gets to the intake, transfer, release, they're processed as they arrive for release at ITR.
Keeps going off. Everything is uniform and there's no distinction between somebody with an ICE hold and somebody without.
No.
Okay.
In fact, the people making the run to go get the inmate would have no idea there's a I-247A on file or not. That's held in records.
All right. Thank you.
Okay, we're going to do the last presentation now, which is from Rizal Ruiz, who's a staff attorney from Immigrant Legal Resource Center.
Okay, great. The ILRC is based in San Francisco. We're a national nonprofit, and we are among a large coalition of groups, nonprofits across the state of California that help to develop the laws that we're going to discuss today. So what I'm going to talk about briefly is just to provide a brief review of the laws that are applicable, because the sheriff and chief have already provided a review of some of these laws, I'm going to try to touch on some of the issues that haven't been discussed. And I'd like to highlight, too, that these laws collectively provide the state floor as to what local law enforcement and other state agencies must do when it comes to cooperating with immigration enforcement, or rather places limits on the type of cooperation they can provide. Well, however, it's important to note that cooperation is entirely voluntary. It is fully within our local agency's authority to decide not to cooperate with ICE in any capacity. And this has already been done in certain counties in California and other jurisdictions throughout the U.S. So again, this is the floor, but there's nothing stopping this county or any other within our state to go farther. Also, I'd like to note that we often give ICE the benefit of the doubt in terms of due process, but I would like to highlight that ICE is a civil agency. There are a lot of differences that arise because of this. For example, ICE frequently won't follow the same constitutional protections that we have in our criminal system, for example. During interviews, when they happen, whether they're in the jails or whether they're out in the community, whether they occur in a home raid, ICE agents do not Mirandize people. This is just an example of the fact that we don't have the same constitutional protections. So even though in the immigration system we do have the right to remain silent, individuals are not advised of this right by the ICE agents who are interrogating them, and oftentimes this information can result in someone being placed in removal proceedings. And just highlighting some of the lack of due process protections that we have in removal proceedings, individuals can be incarcerated. Some individuals will never even have a right to request a bond. And individuals are not provided public defenders. And when it comes to the detained population, upwards of 84% of those individuals are without counsel. So just highlighting the very real consequences that can befall from local cooperation with immigration enforcement. So providing a review of the statutes, because we do have so many laws in this area that have come about in recent years. So we start off with the Trust Act, which became law as in 2014. And the big takeaways here are that the Trust Act focused on detainers specifically. And it's helpful to know that all of these laws touch on different aspects of immigration cooperation. So the Trust Act focused exclusively on detainers. In other words, the circumstances under which, at the time, the sheriff or a local law enforcement could hold someone beyond their criminal release date in order to transfer that individual to ICE. After this became law, we saw several court cases that found holds to be unconstitutional. So after this law, almost every place in California stopped holding anybody on ICE hold, and SB 54 now makes ICE hold unlawful in every single circumstance. Next, in 2017, we had the Truth Act, and I'll be unpacking all of these in later slides, but the Truth Act really focuses on ICE interviews, and it also provides the basis for these forums. And then finally, we have the California Values Act, which is law as of this year, and the Values Act is the most comprehensive of the laws that we have in California. It's actually the most comprehensive law of this type in the entire nation, meaning that it touches many, many different types of potential police-ICE collaboration, but it restricts them to different degrees, but it's very comprehensive. And also note that oftentimes when you hear folks talking about these laws, you hear the Trust Act referenced. The California Values Act does have criminal exceptions that apply in certain circumstances, specifically with notification requests, and those criminal exceptions actually come from the Trust Act. So we actually, the exceptions in the Trust Act were slightly amended and incorporated into the Values Act. So before diving into the nuances of some of these laws, it's helpful to understand the background under which immigration enforcement happens. So an initial question is, how is it that immigration identifies individuals? How is it they know who they're potentially interested in or who they're going to try to arrest? One major way is by fingerprint sharing. And as the sheriff described, anytime somebody is booked into jail, their fingerprints are taken, those fingerprints are shared with the FBI, and then they're thereafter shared with DHS, the Department of Homeland Security. And if DHS has that person in their records in any way, then that'll trigger a ding in their system, and then they'll reach out to local law enforcement to take steps to try to apprehend the individual. But I'd like to take a second to just unpack where some of those triggers might come from. It could be the case that somebody had an order of removal when they were a child. They might not actually have any even memory of what happened. Maybe somebody was an adult and was supposed to go to a hearing and never even got the hearing notice. If you don't appear to an immigration court hearing even once, that's an automatic order of deportation. So just flagging that there are all sorts of types of circumstances that could result to somebody being in DHS's database, and those triggers then result in ICE seeing that the individual is now in local custody somewhere, and that will often trigger ICE trying to take steps to apprehend the individual. ICE interviews in the jails have historically also been a big way that ICE will identify somebody. For example, they'll look at booking sheets and see where somebody was born, and that will trigger then an attempt for an investigative interview. We have seen, as the sheriff described, that because of the Truth Act protections around ICE interviews, that many of these have gone down. However, that does continue in certain circumstances to be a way for ICE to identify who they're going after. And then finally, there are other types of information sharing, database sharing, that provide ICE with the basis to identify people that they are interested in the community. Once ICE has identified that they would like to arrest somebody, the next question is, how do they actually effectuate the arrest? It's one thing to know where somebody is. It's another thing to actually get custody of that individual. Here are some of the common tools that we have are first ICE holds. And again, those were limited with the Trust Act. They were then found to be unconstitutional, and they are now prohibited in every single case under SB 54. Because we've already been moving away from ICE holds in California more recently, really the manner in which ICE arrests happen is either through a notification request, meaning ICE is asking for someone's release date, or in this county, ICE might be able to just go onto the website and see when somebody is set to be released so that they then know when to go to the jail to apprehend the individual. And also transfers, meaning that the individual is actually handed over in local custody. The individual is still in the custody of the sheriff's department, and ICE is arresting the person while the person's in custody. I'd like to note that there are prohibitions on both of these based on SB 54. So the default is they're not allowed to happen unless an exception applies. And we'll talk a little bit about what those exceptions are for both of those circumstances. All of those requests are generally come through this I-247 form, which has also appeared in other presentations. This is actually a markup that our office did that points out some of the concerns that we have based on this form. So I'll just talk about a few of these. But the first boxes allegedly indicate that DHS has determined that there's probable cause to seek custody of a specific individual. Those are the first category of boxes that are at the very top. I'd just like to highlight that these boxes reflect general database searches. They do not necessarily amount to probable cause. So even taking some of the examples that I highlighted earlier, these don't necessarily mean that there's probable cause that the person is removable, or that more importantly, that it would fulfill the Fourth Amendment obligations that we have in order for local custody to be based solely on this form. I'd also like, and then the box, the category below that then highlights the actions that ICE would like local law enforcement to take, whether it's notifying DHS of a release date or maintaining custody, et cetera. So taking some time and talking about the first law that we have. So we have, again, the Trust Act came into effect in 2014. Again, this focused exclusively on holds. Because of some case law and organizing that we had thereafter, ICE holds ended up not being used in California and are now unlawful in every case under SB 54. However, the Trust Act exceptions are still applicable because they've been amended slightly, and they're now the basis for the criminal exceptions in to notification requests in SB 54. These are some of the laws that have been referenced already with regards to ICE holds specifically. So we have a few cases coming out of several federal courts across the country that made it clear that ICE holds, and again, this concerns holding someone for any period of time, even moments beyond their criminal custody, that is unlawful. Local law enforcement may not do that unless there is a judicial warrant. And these cases make clear that ICE holds, if there's custody in and of, based solely on ICE holds, that they do violate the Fourth Amendment, and that they are totally voluntary and unlawful. Moving on to the Truth Act. So again, the Truth Act really focuses on ICE interviews and then also on providing the basis for these forums. So what does the Truth Act do? So we've talked about how ICE interviews are frequently used for all sorts of things. They can be used to ascertain someone's, to see if someone's removable. They have also been the basis to try to get individuals to sign stipulated orders of removal, which is essentially signing away your ability to even fight your case in front of an immigration judge. The safeguards that we have here because of the Truth Act are that before an ICE can interview anyone, law enforcement must provide a written consent form to the individual, which provides the individual 3 options, including that the individual can decline the interview, may proceed with the interview but only with an attorney, or may proceed without an attorney. So those are the 3 options that must be indicated on the forms prior to an ICE interview proceeding. And there are some other important provisions with regards to the Truth Act, specifically some notice requirements. Because even though the I-247 indicates that the individual should be provided a copy, we have seen huge problems on the ground with the individual themselves even knowing if an I-247 has been filed in their case. So under the Truth Act, the individual must be provided with a copy of the form. And then if law enforcement, LEA here stands for law enforcement, if law enforcement does provide ICE with the release date, they should also promptly provide notice to the person and his or her designee or attorney. And here, this notice really does become crucial, in particular for the criminal defenders representing people in these cases. As I'm sure you're already aware, criminal defenders have a duty under the Sixth Amendment to advise their clients of the immigration consequences, and knowing that there's an I-247 in their client's case, knowing that ICE is actively seeking this person and will try to apprehend this person after they're released from criminal custody is surely an important part of this duty. And we have heard some concerning incidents of defenders being notified extremely late, past the point where it would even be useful. And then finally, the Truth Act also provides the basis for providing these types of forums. And these forums will happen on an annual basis, and they've already begun statewide. And then finally, I'll close off by talking about the California Values Act. So SB 54, again, the most comprehensive law that we have on this matter in that it covers a bevy of different types of potential cooperation between local law enforcement and immigration. Oh, pardon me. So this is actually a handout that that a slew of advocates put together that provides a quick review of the different types of cooperation that are limited now. So at the very top, you'll see that, again, immigration holds are prohibited in every circumstance. It also makes arrests for civil immigration warrants prohibited in every case. 287G contracts are now prohibited in California. That's actually the most far-reaching type of collaboration. We had one 287G contract left in the state in Orange County, and that contract has now ended. It also prohibits asking about immigration status or using immigration agents as interpreters. This is an issue that we had been seeing a lot in the Inland Empire, for example. And then it also prohibits providing ICE with dedicated workspace and providing personal information unless that information is otherwise publicly available. Sorry, I'm going to try to move this up just a little bit. It also places limitations on transfers. So again, this is what we're talking about, an arrest by ICE that's happening while the individual is in local criminal custody. These types of arrests, these types of transfers are prohibited in every case unless there is a judicial warrant or I'd like to clarify here that the transfers don't have a criminal exception. So with notification, putting a release dates on a website, for example, that's prohibited unless, for example, they're publicly available. But when it comes to transfers, the criminal exceptions don't apply. So with transfers, what you really are generally going to need is a judicial warrant. So for anybody who is transferred in local custody, you can't transfer just anybody. It would have to be if there's a judicial warrant or if a criminal exception applies. And then finally, I'll just finish this off by indicating that with ICE interviews, we still have the Truth Act. And then with joint task forces, this is speaking to a question that was asked earlier. There are reporting requirements per SB 54. If there are any joint task forces, then the local county must, or local law enforcement are required to report that information to the California Attorney General. And then just flagging that because there is still a lot of work to be done in these areas, that Know Your Rights remain more important than ever. We thank the county for its support in a CLEP. This is the rapid response number that is run by Centro Legal, I believe. And below, we have the red cards that are produced by the Immigrant Legal Resource Center where I work, and those provide a review of people's rights, including the right to remain silent, which again, we really have to inform our communities because ICE will not Mirandize people. And then also, our advice is always to keep doors shut because while we have Fourth Amendment protections, if ICE comes to the home, individuals have to really assert those on their own.
Okay, thank you. Questions, Supervisor Meyer?
Yes, I have some questions. First of all, I want to thank you and Probation and Sheriff's Department for the very helpful, confusing area. And it's not just confusing for me, but I think it's confusing for the broader public. So the information provided today is helpful. It doesn't clarify everything. And even after I ask these questions, I don't know if it'll clarify everything for me. So, first of all, when you say a local jurisdiction doesn't have to cooperate, is that what you said? We don't have to cooperate, or voluntary holds it's voluntary for holds, and that's not mandatory. So I was trying to see if there's a distinction or if it's one and the same.
That's a great question. So generally speaking, nearly all of the cooperation that I've discussed in these slides is going to be totally voluntary. And there are already counties that have placed pretty strict limitations. Santa Clara, for example, doesn't ever allow ICE agents in the jail, doesn't respond to notification requests. So that's all generally going to be voluntary. There are very limited circumstances when there might be mandatory obligations, but they're very, very limited. And in terms of ICE holds, it would be unlawful for local law enforcement to comply with an ICE hold. So, certainly goes even farther than discretion. It would be unlawful.
Okay. And so the cooperation, you mentioned some counties have done this already. How did they achieve that? How was that brought about?
So it was brought about by a huge degree of organizing from.
Well, but I'm talking about the jurisdiction. Is that something Board of Supervisors has
Oh, I
jurisdiction
see.
over it, or is it the sheriff's? How is that actualized legally?
Sure, sure. So it depends on the county. Certain counties are it's the sheriff who sets the policy. There are a few counties where it's the Board of Supervisors. In Santa Clara, it was the Board of Supervisors who put together that policy. In San Francisco, the Board of Supervisors put forth that policy, and the sheriff said that he would follow it. And that was under a previous sheriff, and now we have a new sheriff who has also said that she will follow that policy.
So I haven't finished my questions, but I just want to continue down that track for a second. So how does Santa Clara's Board of Supervisors do that? I'm asking County Council. Yeah.
It was my understanding that at the time Santa Clara did that their jail was not being operated by the sheriff. And so that they had an officer who was not the actual sheriff who was operating the jail.
So that's how they achieve that. Is there any lawful approach to this Board of Supervisors doing that in this county?
Well, one of the things that she stated was that in other jurisdictions where the sheriff has agreed to do it,
Right.
They've done that. But the state law provides that the sheriff shall have sole and exclusive authority over the jail. So in a situation where the sheriff has taken a different position than the Board of Supervisors, the sheriff's position on the issue would control.
Okay. So I don't want to put words in your mouth, but I'm just trying to make sure I'm clear on this. So in this county, we could do this, but ultimately the authority would lie with the sheriff.
I mean, your board could espouse certain policy and take certain positions, but the authority when it comes to implementing is the sheriff's.
Okay, all right. Just want to be clear on that. Now, what would the rationale be for not cooperating with, this is with ICE, right? What would the rationale be? Is there no justification for cooperating with ICE? I'm asking the attorney this now, not you, County Counsel, but the attorney from the
So in the jurisdictions where this has happened,
Information Resource Center.
yes, it's been done for a bevy of reasons. So community trust has been one huge reason. Obviously, we're in a crisis with all sorts of communities of color when it comes to potential trust in law enforcement. We have seen through surveys with community members that individuals are increasingly scared to report crimes, to act as witnesses when they know that doing so could result in their being turned over to immigration. So that's been one huge impetus, is to help repair some of the trust that has been lost. And we have seen that this has had some impact on the ground. There's also a huge concern with the fact that we already have an existing criminal system to address certain criminal offenses. There's no reason to turn to an immigration civil system to essentially punish somebody twice for the same offense. So it's also a parity in ensuring that we don't have second-class citizen or access to justice.
Now, I have just a few more questions because I'm really trying to understand all this to the best of my ability. Why isn't there due process associated with this? Because I know you said there's no due process proceedings.
So referring to immigration proceedings, if you look at their immigration regs, there is a right to due process. But when you look at the way this actually functions in person, it's very hard to see how this happens. So we actually have immigration court right here in San Francisco.
Okay, so there should be due process. It's just not being implemented.
Correct.
Okay, all right. And then I know this county is a welcoming county, and we provided funds. You referenced that in your last slide. Do we have any indication of the outcome that's been associated with the funds we've provided? Like how many people have been served, how many people we've helped out, what the outcome has been, et cetera, et cetera. Do we have any of that information to your knowledge or to the staff's knowledge? Because didn't we provide $750,000 and wasn't it matched?
Yes.
Yeah. Do we have any?
We do have statistics. I don't have them in front
Because
of
I
me.
think it'd be interesting to see, and how our funds have been utilized in the results. Because I'm hoping the results have been good results, but I don't know. And so I was just curious to see how the funds do any of our funds go to help to the Immigrant Law Resource Center?
I unfortunately don't have those exact stats. I know that our office doesn't receive any of the funds.
Okay.
I know that we have some other really great allies in the community, like Centro Legal and others, who do receive the funds.
Yeah, we can get those, but not from her.
Okay, so great. I'm just trying to understand. So your office doesn't receive any funds, but you understand this very clearly. Okay, the immigration law. And ICE was created after 9/11.
After 9/11, we had a huge restructuring of our immigration system. It's actually interesting because after 9/11, immigration became even more so about securing our borders, and the framing and a lot of the rhetoric really shifted around that time. So we saw a huge restructuring with DHS and an increase of aggressive tactics after that.
And did ICE come about as a result of 9/11 with Homeland Security?
So we did receive, let me confirm, but I believe so.
No, ICE existed before.
So ICE was in existence before 9/11?
Yes, definitely.
So because if ICE existed before, what's made it so controversial now? Because it's been in existence under a lot of different administrations. I know with the Trump administration, it's all, the ICE agents are doing things people don't really concern themselves with. What's occurred that's made this so controversial?
Of course. Yeah, and to clarify, we have had immigration enforcement engage under different agencies over time. As some folks have described it, used to go under different names. I think what's distinct right now is the manner in which immigration enforcement occurs. So even under the Obama administration, immigration enforcement was still happening, and quite frankly, at even higher rates than today. So that this is something that advocates have been working on for years. So for us, it's more of the same, but there is a certain urgency in the tactics that we're seeing today. We are, immigration is a bit of a pendulum. You have some, more severe tactics at certain points in history, like we think about the Bush-era raids where you had the more aggressive worksite raids, for example. We saw some of those activities quell under the Obama administration, and right now the pendulum is moving toward more aggressive tactics. So what's interesting is that even though we still have had the highest deportation in 2012 under Obama, we're still seeing deportations, increase, and the tactics, the manners in which they're happening are becoming extremely concerning.
I see. So that is the distinction. Okay, and I think then just my last question. So I don't know if from President Chan. So the funding that we've provided and the work that's being done through the program and through the Public Defender's Office and that sort of thing, we'll get some report on the outcomes.
Yes, we can.
Okay.
Yeah. Supervisor Haggard.
Sheriff, real quick on, I think it was slide 10, the notice of requirements for ICE requests, and it says upon receiving an ICE request, LEA shall provide a copy in person. And then there was a part about LEA provides ICE with release dates. LEA shall promptly provide notice to persons or his attorney or designee. Is that something you guys do?
No, we don't. So if I got your question right, do we notify ICE about?
No.
What?
Okay.
What slide?
It's on slide 10. Maybe you can put slide 10 back up. It says upon receiving an ICE request, hold notification or transfer, LEA shall provide copy to person.
To the person?
Yes. Do you do that?
By law.
You do it?
Yes.
Okay. And then the LEA provides ICE with release dates. If the LEA provides ICE with release dates, the LEA shall promptly provide notice to the person or his or her attorney or designee. You do that also?
Yes.
Thank you.
Okay. Any questions? Yes.
Respond to Supervisor Valle's question and then clarify one other thing that was stated. So the SB 54 does require that reports be made to the Attorney General's office, and it states in the manner specified by the Attorney General's office, or to the DO, the reports are to the State Department of Justice, in the manner specified by the Attorney General, and it's our understanding that the Attorney General hasn't issued the advice letter yet on how they want that to be received. But that is a requirement that it be done, I believe, on an annual basis. So there will be reporting, and I believe that information will be considered public record information once it's reported, well, as reported to the Attorney General. And then there was one other point in the last presentation where the slides that, I'm sorry, Ms. That she provided are correct, but she had said that the only conditions under which the sheriff could cooperate with transfers to ICE were where there was a warrant based on a probable cause finding, and that the other exceptions didn't apply. But I should have clarified. Yeah, so those other exceptions do apply, but her slides have the correct information on it. The slides are corrected there. Those are the limited circumstances on which you could transfer.
Yeah, so to clarify, and pardon if I, got turned around when I was explaining it, but correct that when it comes to transfers, that transfers may occur under the Act if there is a judicial warrant or if the individual falls into a criminal exception from the revised Trust Act criminal exceptions.
Okay. I had two things. Ms. Ruiz, does Santa Clara do the I-247s then at all?
So their policy, they have a pretty broad prohibition on ICE access. They basically say that they won't cooperate with, that they won't allow ICE agents into their jail at all unless they have a judicial warrant, unless ICE has a judicial warrant. And when it comes to any request from ICE, they basically say that they won't even consider a request unless it's accompanied by some type of reimbursement. And since ICE they don't do that, then they never even get to the circumstances under which they might consider one.
So they don't fill out those forms then, the I-247?
I would have to confirm. I would assume that they still receive them, but that they don't respond to them, but I would have to confirm that.
Okay. And then I had a question. I see the public defender here. Can I ask you something? Because I'm sure it's going to come up. Okay, it's not. I think you can answer this. On this issue of posting the release date, because you and I had discussed this, what is your opinion about that? Because you said there was some positive to it.
The positive issue with regards to the release dates when families want to know when their family members are being released. That's the only positive that comes out from it. So if we get a call from a family member who wants to know when a client might be released, that's when it's helpful. Does that make sense?
Okay. So there's positives and negatives, right? I mean, because we discussed, you and I had this discussion because I remember when it happened about 6 or 7 months ago, or something like that. And you said that some of the families appreciated having it posted, but.
Yeah, so being able to give a family member who has someone who's being released a contact point where they can find out where their loved one's being released, what time of day, that is helpful. On the immigration context, that front, it's not helpful.
Okay, all right, thank you. Yes?
That's not of you.
Okay, thank you.
I wanted to ask one more question of either county counsel or the attorney with the Immigrant Legal Resource Center. So in those counties, and you mentioned Santa Clara and San Francisco, that have restricted cooperation, if we were to consider doing that in Alameda County, we would need to get either a change in the law, or could the Attorney General of the state authorize that?
If the question you're asking me is, could the Attorney General direct the sheriff not to cooperate?
I'm just trying to, I'm not saying we shouldn't cooperate, because I have mixed feelings about all this, because I do believe we need to have appropriate immigration policy. What I'm trying to understand is, right now that authority lies with the sheriff, as I understand it, in Alameda County. But how could we overcome that? Could the Attorney General do that, or could the state legislature change that? I mean, how could that come about?
It would likely require a legislative change, because it is a state statute that gives sole and exclusive authority over the jail to the sheriff. And I think I've mentioned before that previously that language said something to the effect of the authority of over the jail. The sheriff shall have authority over the jail, and then it was revised to say the sheriff shall have sole and exclusive authority over the jail. So it's over the years it's been revised to clarify and increase the clarity regarding that lies with the sheriff. So it would likely have to be changed at a legislative level to harmonize that, and perhaps also put some different specifications specifically to these issues about enforcement. The sheriff is a state actor with respect to certain functions, and so the sheriff does take some guidance from the attorney general in terms of law enforcement issues. So, but it would probably require some legislative fix.
Okay, and once again, I'm not saying I want to do that. I'm just looking at exploring all the possible options. Could that be mandated judicially? Could a court order mandate that?
So a court, in a proper case, and when there's a proper case in controversy where issues are brought before a judge, there's a possibility that if a judge issued a mandate that interpreted the laws differently, the sheriff could be required to follow that mandate.
Okay.
But it would need to be a properly framed case that
Okay.
made those issues
So
right.
once again, I don't want anybody out there to get the sense that I'm trying to suggest that happen. I'm trying to understand all this as a policymaker. Thank you.
Supervisor Valle.
So along the same lines, earlier, I think, Donna, you mentioned that Santa Clara County has a different model where the sheriff is not in charge of the jail?
So I can't say that that's the model today. I think they may have gone back to a sheriff model today. But at the time, it's my understanding that at the time that they first took the action, that their jail was run by a corrections officer or a position of a different type. And so they had, the sheriff was not, and it has something to do with some historical timeline with respect to which the sheriff, in that county, the sheriff did not have control of the jail. And then there were laws were changed at the state level about who has control of the jail and that there are timelines involved. But they were within a timeline that allowed them not to have their jail run by the sheriff, and that they had taken actions to not have their jail run by the sheriff.
Okay. Sheriff, do you know the answer? Are there counties in the state of the 58 counties that have jails, but the sheriff does not run them?
No, the authority to run the jail got back to Sheriff Smith a few years ago. All the jails in the state are currently run by the sheriff.
And that was through the legislature?
I don't know how that came about.
Okay. Maybe County Council, can you bring back some more information on this question? All right.
We can, because this has come up before about, and I know we looked at it in the past about how it was that Santa Clara didn't have the sheriff over the jail.
Thank you, Sheriff.
Okay, I'm going to call the public speakers now. I'm going to call you 5 at a time. You each have 2 minutes. So
There was a window.
we're going to start with Valeria Suarez, Cynthia Marfin, Judith Stacy, Leo West, and Yadira Sanchez. If you need a translator, we'll give you more time. Are you here, any of you? Go ahead. Go ahead.
Yes. Hello, I'm Valeria Suarez. I'm here because I'm appalled at how Alameda calls itself a sanctuary city or a sanctuary county, but we have like clear like showing how like the sheriff is collaborating with ICE, and there's already a number of 386 people that have been transferred. Something that was brought up was how has it like the need for a judicial warrant, and how have we like community members have never seen these judicial warrants and what exactly this looks like. Also, I know that it was mentioned how people can be transferred without this judicial warrant, and there's some exceptions. But how can we know that? Because if this isn't public knowledge in terms of like what these exceptions look like and how like can folks be transferred, then I think it remains that for a community we feel unsafe to have any form of interaction with law enforcement because we immediately associate it with ICE, and we feel like in this community we feel unsafe to like by understanding this and understanding the collaborations and the way it works with it. So I raised this question of how can we continue to like claim that we're here for like diversity and here for immigrants and we're a sanctuary if we're truly not making our own community feel safe. Good afternoon. My name is Cynthia Morfin. I'm here with the East Bay Alliance for a Sustainable Economy, and I'm also a resident of Alameda County. And so to revisit the topic around the release dates, the Sheriff's Office began releasing these dates on its website April 2018, and it was mentioned early, which is, just a few months after the California Values Act went into effect. And it was mentioned earlier that this was done because of a law that had passed years before. So that sounds a little bit contradictory and also sounds like a clear abuse of the loophole that contradicts the will of what Californians want. The Sheriff's Office continues to post release dates. So the question is, will the Sheriff's Office take any efforts to take down this release information?
Hi, I'm Judith Stacy. I live in Oakland. I'm with Freedom for Immigrants and the California Sanctuary Campaign. And I want to say that there really is a discrepancy between the stated policies of Alameda County and of Oakland and many of the cities of the county and the deep beliefs of the sheriff and he actively fought the implementation of SB 54. And this posting of the release dates is a clear runaround of that. And I want to say I was visiting detainees in West County facilities, detention facility all year, and I worked with a number of people who had been picked up in these nefarious ways. For example, an 18-year-old Oakland resident with a stellar school record was stopped in a traffic stop. He was taken to Santa Rita, and he was charged with a crime he did have in the car. They found a weapon. But mind you, this is someone who came here at age 3. He's now under removal proceedings, and indirectly because ICE got him. And they got him after he posted bail. It's very important for the supervisors to understand the double jeopardy that this implementation of these laws qualify. He's under the criminal proceedings, and in fact, I believe he's now being released because of a stellar record and no use of the weapon ever had been made. But because of that, he's under removal proceedings, and this is all because of the direct transfer. This occurred 3 days before SB 54 took effect. This was in December, but the clear spirit of law, they did not have to pick him up, and the communication with ICE is really unfortunate. I really urge you to make sure that they stop publishing the release dates. That's a clear bypass of and an attempt to get around the spirit and the intention of SB 54, and certainly the spirit and desires of everyone who fought for those laws in our community and for the supervisor's policy. Thank you.
Hello, my name is Yadira Sanchez. I'm with the California Immigrant Youth Justice Alliance. Thank you, Willem Chan, Supervisor, for the coordination of this Truth Act Forum, and all of the other supervisors for your questions. I'm also a resident of Oakland and a concerned community member, and also appalled and concerned to the way that Sheriff Ahern publicly is collaborating with ICE. We know of 386 people that are in paper, and that we know that as of now, there's only twice a month interactions of ICE coming to the jails. But how do we actually ensure ourselves that this is the truth? How do we know that this is not more interactions that ICE is having with community members in jails? How do we know that the Ahern is not lying, because that is a track record that he continues to have, to lie to the community and to collaborate with ICE to funnel local deportations? I think that it's clear that we need to move to a resolution that ends the police, local enforcement, and ICE collaboration. There is no need for immigration to be, for ICE officers to be interacting in our jails when it's a different civil matter. We know that there is, in paper, 386 people that were transferred to ICE, but we also demand that those judicial warrants that need to be signed by a judge to be shown by this by this department. If this, we know that, understand that this is a complex issue, so why are we allowing Ahern to take manners and to decide himself who is going to be deported and who is not? Why are we allowing Sheriff Ahern so much power, and why are we giving him so much money into his budget to continue to separate families? It's clear today that our community doesn't feel safe when we know that ICE is roaming in the county jails. It's clear to our communities that we don't want Sheriff Ahern to continue to funnel deportations. And it's clear today that he has found loopholes to continue to collaborate with ICE by the release of dates and so on and so forth. So I'm here to also call on the board of supervisors to enact and to pressure Sheriff Ahern to stop this collaboration, because this is an atrocity, and we know that he's abiding by the Trump administration. In the past, he has said that he can identify the person by the way that they speak
Your time is up.
and the way that the luggage that they carry. Thank you.
Is Leo West here?
I don't want this county or any city or the state to interfere with the federal law, because it is us, the U.S. citizens, who pay for the price for it, not the politicians. This county has contributed millions of dollars to provide free lawyers for illegals. How much of that money you individually, the city council individually, put into that fund? I, as a U.S. citizen, a senior U.S. citizen, cannot get a free lawyer from the county to defend me from the discriminatory practices of my landlord. But there's money for illegals. Now, we know the case in San Francisco, very notorious, of a murderer who had 3 free lawyers. We know that currently in LA, the police are looking for an illegal who committed multiple murders and was deported 6 times. He came to California because this is a sanctuary state for criminals. On top of that, all of the illegal displaced U.S. citizens from their jobs and housing for the benefit of the corporation. And those are the interests you all defend.
Okay, next, Pancho Ramos Stieri, David Brazil. All right, just a second. Juan Preto and Jose Bernal.
I just want to say that through the Public Defender's Office, the county provides money through the Public Defender's Office, and the Public Defender's Office represents folks who are in need of those services, legal services, who are indigent, regardless of their nationality. So we have provided additional resources so that the county could do that with the undocumented immigrant community as well. So we do provide funds for everyone.
Hey everyone, my name is Juan. I'm with the California Immigrant Youth Justice Alliance, an undocumented-led statewide organization fighting for immigrant rights. And I live here in Oakland, California, and work here in Oakland, California. And so the atrocities of Sheriff Ahern concern me gravely as an undocumented immigrant here. I think earlier someone asked, like, how does the ICE decide what they're going to do? And I want to say that it's white supremacy. They want to get rid of our communities from this country because they're terrified of our numbers. And any collaboration with it is a role that it's playing in white supremacy and in ethnic cleansing. If you read the definition of ethnic cleansing, deportations are a part of it. And I don't know about y'all, but after last week, I'm pretty tired of white men feeling entitled to abusing their power and lying to community members. And so I'm here to denounce that and demand that we do everything in our power for him to stop publishing release dates. He's already said he knows that ICE is using it. He can't claim that he doesn't know that they're using it. What are we doing in our power to stop this man and other white supremacists in uniforms from getting rid of our community members? We are 1/3 of Alameda County. That's the immigrant community, 1/3. Do you want it to be 0 out of everyone? because they have the power to do so. And if we continue to sit idly by, they will get rid of all of us, and they'll start with us and they'll go to the next community. But we need to rise up against them. Thank you.
Good afternoon, Commissioners. My name is David Brazil. I'm a pastor and I'm an organizer with the Faith Alliance for a Moral Economy. As a Christian, I walk by the law that we have to love our neighbors as ourselves. And so I actually want to take a moment to signal boost my comrade who just spoke, because I am a beneficiary of white supremacy, and maybe it's easier to hear some of these things coming from a white man. But that it's time for us to recognize that the way immigration policy gets implemented here locally is the outcome of the racist and xenophobic policies that are happening on the federal level. And if we're going to fight these racist policies, we need to fight them here, and we need to recognize the forms they take locally. And the forms they take locally is this spirit, this defiance of the spirit of the will of the people in this letter of the law, which is deeply disingenuous. It's deeply disingenuous, the report that Sheriff Ahern just gave us. We know that he's collaborating with ICE. This form submitted by his office shows us incidents of access. These are things that he did that he does not have to do. Responding to an ICE hold. Why is he responding to ICE holds? We just heard that Santa Clara doesn't have to do that. Providing notification to ICE in advance of the public that an individual is being released. He doesn't have to do that. He doesn't have to do anything. He doesn't have to communicate with ICE. He doesn't have to cooperate with ICE. ICE was founded in 2003, a reorganization of INS after 2001. It's a racist instrument. That's why people are calling for the abolishment of ICE. We have to stand against this. This is what's separating children and families now. If you want to be standing on the right side of history in this moment and looking back and saying, I stood against white supremacy, I stood against fascism and racism in 2018, you need to stand against this man and his racist policies.
Hello, I am an interpreter for Pancho. First, I'm going to read his introduction in Spanish, and then I'm going to read it in English.
You'll have 4 minutes, double, okay.
Mi familia me dice Pancho, mi apellido es Ramos Stiriele. Los lunes practico silencio, pero quiero que sepan que los quiero mucho. Soy uno de los al menos 22 millones de seres humanos indocumentados en esta parte del planeta y estoy aquí orgullosamente sin documentos y sin miedo. In English, my family calls me Pancho and my last name is Ramos Stiriele. On Mondays, I practice silence, but I'd like you to hear that I love you all. I'm one of the at least 22 million undocumented human beings in this part of the planet, and I'm here proudly undocumented and unafraid. Here are the 2 questions. 1, prior to the Truth Act, how would ICE request to interview someone in the sheriff's office custody? Did that process change after the Truth Act? Second question, have officers received training regarding complying with the Truth Act? If so, what does that training entail? Is there a training manual with this information? Thank you.
Sheriff, do you want to answer if your officers are trained on the...
I have a number of trainings that go on regarding our policies. There's an electronic version that we do through a process called DMS. There's a ongoing training we do, we call it muster training, where we go over the policies and the changes of the law. There's an annual review, twice a year we go over case laws and legislation on how it changes the way we do our policies. So there's ongoing training that goes on in regards to that. It's also done through our jail training officers when they first become a deputy after graduating the academy. And I forget the second question. One was about training. Oh, how did ICE go about coming into to do their enforcement? As I said before, ICE used to come into our jails every day about 5 o'clock in the morning. Each arrest record is on a consolidated arrest form called the CAR. CARs are stacked up in a bin. They would come in, they'd thumb through the arrest records and look at individuals that they suspected may be undocumented based on a number of different criteria. And then they would talk to those individuals while in the intake section. They no longer come into our facility. We don't allow them access until for those type of reasons. They don't come in for the interviews because of the Truth Act. There's been 0 events recorded.
Okay, thank you. Is Jose here? No? Okay. Diana Bond, Janet Newman, Veronica Hernandez, or maybe you. Okay.
Hello, my name is Janet Newman. I'm a volunteer with Freedom for Immigrants. I spent last year visiting detainees at the West County Detention Facility until it was closed. One thing I learned there was that these laws and these numbers and the things that we were seeing, all these statistics, are very real. They refer to real people and real consequences for real people's lives. While I was there, I met several people who had been picked up after being released from the jail in Alameda County. In two cases, they were young women who had been arrested on trumped-up domestic violence charges. Their husbands or boyfriends had accused them of being violent. They were both tiny little women. Obviously, the charges were trumped up because they were let out of jail quickly, but they were let out of jail into the arms of ICE, and then they were detained at West County. In one case, this woman had a disabled daughter. Her daughter had to go into Child Protective Services because she was in detention. This was separation of families. This was what all of us, I'm sure, would look around and say we were horrified by what was going on at the border with the separation of families. Well, it was happening here. It's happening here in Alameda County because of this cooperation between the jails and between ICE. And these young women were walked outside. There was ICE waiting for them. They're detained for weeks, months in jail because they had no way of getting out. This is unfair. This is unjust. Thank you.
Mr. Carson.
I have a question. I know that when this board took an action regarding the publishing of dates for people to be released, it was really because a number of reentry organizations had approached us, and I think it might have been Diane Bellis, who was the public defender at that time. You can correct me on that. But a number of groups, all of us, none of us, and other reentry groups had said that it was very challenging to have someone there to pick them up when they were being released. It was really a request from a number of prisoner reentry groups. The question is really, if there was no publishing of time of release, would I still have access to knowing information about individuals who are going to be released from their custody?
Yes, and for clarification and some of the misstatements here, the request for your board was to do that about 2012 or 2013. So we've been working on a program. We went out to bid. A company called Adams won the bid. They took over the records management system to publish those information from 2012 to 2013. The access rules came into effect well after that, so we've been trying to do this for a number of years. As County Council will agree with me, the records for release dates are public records, so ICE could have access to them. They just wouldn't. There's a number of ways they can have access to those records. So it's public record.
So regardless as to whether the action that the board took on publishing them or not, they would still have relatively equal access to that information?
My contention and statement is our actions were based on your request, and to be more efficient at the jail, we provided those release dates like we've been doing, trying to be informative to victims of crimes with the VINE program. And your board was one of the first to do that decades ago in the 1980s, I believe.
Maybe the, oh, okay, go ahead.
Did she have a response of the
I have a question what you asked.
Okay, go ahead.
So, Sheriff, you had mentioned that ICE used to be in your facility every day. And then you said they only now come about 1 or 2 times a month?
Correct.
Do you think that's because the relay states are posted? Do you think there's any correlation?
No, that's with the SB 54 and the Truth Act. They're very ineffective by coming into our jail. When they used to remove individuals on a daily basis, they now.
I heard that. I was just wondering if you thought there was any correlation between that and also that you're posting the release dates.
No.
That ICE is now coming in and looking, not looking.
No.
Okay.
Did you want to say something?
Of posting release dates. If release dates are posted, that means all that ICE has to do is just go onto the website and find someone. That makes their job incredibly that much easier if they're trying to apprehend somebody. If ICE has to request the release date of every single individual, that does make their job harder. So even though it might still be public either way, you're essentially making jobs a life that much easier. So it does have practical effects on the ground.
Yeah, I think, I don't know what you think, Supervisor Carson, but it might be good to just revisit this issue and look at both sides of it, maybe in public protection. Because the only reason I didn't raise it when it happened was because of the benefits to some families, right?
On some level, and because I don't want to pit reentry groups against immigration rights groups. I mean, that's a very delicate balance. I myself have been working inside San Quentin for at least 20 years, going on a regular basis. And one of the big issues has been being prepared for release, especially when you've been disconnected from families and others throughout that whole time you've been incarcerated. Matter of fact, we're doing a welcome home thing to some people from San Quentin in a week. And so for them to not be able to necessarily have access to communication with families, this gives an opportunity for families to better prepare for them to come home. I understand notification for individuals who should be notified that somebody's a predator is about to release. But I also don't know how we deal with the issue that consistently is raised by people who are incarcerated around being able to contact when they don't have the means to family members or a support base upon their date of release. What do you say about that?
So I know that Elisa from the Public Defender's Office is here as well, so she might have something to add as well.
Yeah, but I'm asking you for your response.
Sure. And this issue comes up in other counties as well. And I think, this information is still publicly available. I mean, obviously, I think it's important to reach out to all stakeholders. I equally think it's important to have them at the table before making any decisions. I agree that we don't want to be in a position to pit groups, and usually all of these groups are talking when it comes to these issues. I would suggest, but again, defer to some of my colleagues here, such as the Public Defender's Office, that information is still available to those families if they call. It is still...
That's the problem. There's been and I don't want to argue the fact, because I think that it should come back to public safety, because it was a while back, but there was a direct request at that time on the part of the activist group who were doing reentry work. And that was because there has historically, kind of universally, been a disconnect from people while they're incarcerated with relatives and support groups while they're there. And so people would not know that you're going to be released on this day, so they would not know to call you and say, when are you getting out?
So one idea, and again, I greatly defer to my CJ colleagues on this, but maybe doing additional advocacy. If that's a gap that exists in that community, maybe doing additional advocacy with that community to ensure that they know that this is a resource. Again, I also defer to my criminal justice colleagues and the public defenders in particular.
A couple of points. One, people from the outside can't call in to speak to Johnny, right? The Johnny has to call out to make contact with them. So another reason for the application is that people from the outside can always check regarding somebody's release date. Next, it's complicated in that some release dates get changed. Somebody will have a release date, but they have a pending charge that hasn't yet been resolved. So those dates change. So that's why it's best for us to be on the app. Next, we had number of people answering calls. With 2,500 people in custody, we get a number of calls. What is the release date? And that takes up time, effort, and it's costly. So the application is more effective and efficient for us to utilize.
Okay, well, I think, as we said, we don't want to pit one group against the other. These are both...
Because they're both marginalized.
Yeah, very, very
both
disadvantaged
marginalized
populations.
Groups that both need to have support
right.
around their issues. And, we already have administrative leadership in Washington, D.C., further dividing us all day long.
Okay, so why don't we have public protection look at this issue a little more, okay? All right, Diana, was Diana here? Did she speak? I'm sorry, I'm losing track of what I'm doing here. Okay, Veronica, Nicole Zapata, Sandy.
Hi, I'm Sandy Valenciano. And also, I did want to comment on the previous conversation that in Contra Costa, we are having conversations about this with reentry groups. And actually, and a question would be to Sheriff Ahern is, in switching this and implementing public information, what did coordination look like with reentry groups? Because what we found in Contra Costa County was that reentry groups actually weren't included in the conversation about the implementation of publishing data. So I think that would be also a good part of the good conversation to have. And I think another thing that continues to be unclear is what does it look like when notification is made to ICE and ICE shows up for an individual. Early this year, I had someone contact me who was a mother of a DACA recipient who Sheriff Ahern actually notified this person who was a DACA recipient and disclosed that he was a DACA recipient to the Sheriff's Department. And unfortunately, he was handed over to ICE on a charge. This was a person that had never had any convictions. This was a person that supposed to have been released because he was booked over the weekend. And unfortunately, as his mother who hasn't slept and still hasn't slept, because what ended up happening is that her son ended up to self-deport because he kept being harassed by the Sheriff's Department following. And to clarify, just because I don't want to run out of time, so what ended up happening is that the mother got notifications that her son was going to be released on Monday morning. She was there at a lot earlier than that release time, but still her son was handed over to ICE. She didn't even get to see him release. So I'm really confused that if he's not holding people to transfer them to ICE, what does it look like actually, right? And when ICE arrives, how does he not hold them for ICE when families there waiting for their loved one to be released and they still don't see them? And I'm really confused about this because the public defender's office hadn't even received notice of this individual being transferred or notified to ICE. And I'm really concerned that why isn't there already a protocol where the public defender receives all information of when the Sheriff's Department is responding to notification requests from ICE. And unfortunately, tragically, this young person who thankfully we were able to release that day because that person had community support. We released that individual that day that he was transferred to ICE. But unfortunately, when he was released, he was being harassed by the Sheriff's Department, who the police department and the Sheriff's Department continued coming over to the individual's house, so much so that he was so terrorized by the experience of being transferred over to ICE that he self-deported. Being a DACA recipient, someone who could be in this country, right, and could work. And so I just want to clarify how does the collaboration look like? Because what it sounds like is really Sheriff's Department's holding people for ICE.
Hi, my name is Nicole Zapata. I'm a community organizer with the East Bay Alliance for a Sustainable Economy. I've also been working in Contra Costa County to end sheriff and ICE collaboration. And I just want to echo Sandy's comments about regarding the issue with reentry groups. What we see here is no different than what is happening over there. The same xenophobic and racist policies are being carried out across counties. But you have the community here and all across the Bay Area saying that this goes against our values, this goes against our beliefs. Yet the sheriff continues to align himself with the Trump administration, threatening the well-being of our community, and like my compañeros have stated, advancing white supremacy. They say it's not about race, but about keeping us safe. But look at who's being targeted. Look at which immigrants are being targeted and labeled as criminals. We're here to say that we won't allow these policies to be used in our name to keep us safe. This doesn't keep anyone safe, but people who look like Ahern. ICE is a rogue agency, and this county has no business in collaborating with them. So knowing that Ahern has been vocal in supporting an anti-immigrant agenda, my question is, did the sheriff's office share information proactively with ICE or only in response to ICE requests? Thank you.
Is Diana or Veronica here? Okay. Hunter King, Alicia Whitfield, Lisa Knox. Any of you here? Okay.
Hello, good afternoon. My name is Elisa Whitfield, and I work for the Alameda County Public Defender's Office in the Immigration Representation Unit. So I work with non-citizens who are clients of the public defender by defending residents of Alameda County in their removal proceedings in immigration court and also on appeal. I wanted to say first my thanks to the Board of Supervisors for their leadership in supporting immigrants by providing funding for removal defense for families in Alameda County. Our program helps to keep families and communities together, and thanks to this funding, we have stopped deportations, helped protect due process, and reunited families. We also monitor immigration enforcement trends and local compliance with California laws regarding immigration to the best of our ability. And we're very appreciative of the protections provided by the Truth Act. I would like to thank the Sheriff's Office for working with our office to add information about whether ICE has requested a notification for a particular person online. So that information is now online within our system. However, knowing whether information has been requested about a particular person is only the first step. First, ICE requests a notification regarding when the person is leaving the sheriff's custody. And then in some cases where the person is not protected by State Bill 54, the sheriff does notify ICE in order to let them know when the person is leaving custody. And the provisions of the Truth Act require that when ICE is notified, that the person be able to designate an attorney to also be contacted. And the issue we have encountered is that as the Public Defender's Office, often our clients do not have a particular attorney assigned yet to their case, or they're not aware of the contact information of their attorney. And we've been told by the Sheriff's Office that in order to receive this particular protection of the Truth Act, the person has to designate an attorney in particular. So we would like to emphasize that if the Public Defender's Office represents someone which could be verified, anyone at the Public Defender's Office could be notified. And as we've mentioned to the Sheriff's Office, we would appreciate the opportunity to set up a system that allows for timely and effective notification to our office as a whole. And then regarding the issue with the reentry groups, that is something that we would have to brainstorm further with the reentry groups, and the public defender is here as well. And I believe that's something that we should think about further.
Okay. Is Lisa Knox or Hunter King here?
Hi, good afternoon. My name is Lisa Knox. I'm with Centro Legal de la Raza here in the Fruitvale, and we are the largest provider of immigration removal defense services in California, and we're a member of the ASILP network. So I'd like to first start by thanking the Board of Supervisors for their support of the ASILP network and of due process for immigrants. And I'd like to use my time to tell the story of one of the dozens of people who this year has been taken into ICE custody as a result of Sheriff Ahern's policies. His name is Jose, and before he was detained by ICE, he had lived in this county for many years, has a U.S. citizen wife and 2 small U.S. citizen children, was working and had been employed for many years in this county. He was detained by ICE. He ultimately won his immigration case and is here lawfully, has the right to remain here. But for 9 months, he was separated from his family. And during that time, his wife and his children were evicted from their apartment. He missed his daughter was at that time, I believe, 2 years old, so he missed about a third of her life up to that point so far while he was detained. And even though he was ultimately released, when he was released, he said to me, "I'm happy that I'm out and I can be with my family, but I can never get that time back." And so this is what the sheriff's collaboration with ICE is doing to families and to our community. And I urge this board to stand with immigrants and do all they can to hold the sheriff accountable for his policies that are separating families and ruining our community. Thank you.
Supervisor Vaya.
Can I ask the previous speaker from the Public Defender's Office to step back up to the mic, please? You had a very specific request.
Yes.
Can you state it again, please?
Sure. The very specific request is, under the provisions of the Truth Act, the person, when ICE is being notified of their release date, also is allowed to designate an attorney to be notified at the same time. As the Public Defender's Office, the person often doesn't know who their attorney is specifically, and because of that, they are not able to notify the Public Defender's Office as a whole. Or the Sheriff's Office has told us thus far that it's only possible for them to designate one attorney, not the entire Public Defender's Office. So we would like to set up some sort of system where they could state, "I'm represented by the Public Defender's Office. I would like to notify the Public Defender's Office."
Is that possible, Sheriff? Yes, sir.
So, we try to notify the public defender, but many times upon release, there is no attorney that's been assigned to them. Right? Their misdemeanor offense, they haven't yet made a court appearance, so they haven't yet met their public defender. If the request is, if we get a I-247 request, that we also ask them for their attorney of record. If there is none, contact the Public Defender's Office. I think we could try to facilitate that, and we have offered that.
Oh, so who would be the point of contact for the PD's office and your office on this issue?
We've worked with the Public Defender on...
No, in your office, who can the Public Defender's Office communicate with about this request?
Captain Russell can take care of that request, Tara Russell.
Okay.
And next, people keep making reference that we're notifying ICE. We don't notify ICE of any charges. ICE finds out that there are individuals in custody most times through the fingerprints. Our people don't call ICE, make emails to ICE, have appointments with ICE. They search the databases based off of the federal fingerprint that they get. So my staff and I are not notifying ICE as being alleged.
And what's the captain's name again, please?
Captain Tara Russell.
Okay.
Works out at Santa Rita Jail. She's in charge of the Detention and Corrections Administration.
All right. Thank you very much.
Okay, next we have Lida Pena, Eduardo Cruz, Gloria Estevez, Jackie Gonzalez.
Hi, I'm Hunter King. I was in the last group. I'm with Causa Justa Just Cause and a resident of Oakland. So as we saw from the sheriff's presentation, we overwhelmingly see that ICE is requesting information about Latino males, and you as the Board of Supervisors asked the sheriff why he thought that might be. I'm not surprised that he declined to give a comment or to speculate. And the reason for that is, one, that he lies, and two, that because the answer is white supremacy, the answer is xenophobia, the answer is racial profiling. And Sheriff Ahern has proved again and again that for both himself personally and for the policies of his department, that these are the values that inform his practices. So I'm here today, and I would like to know if the sheriff's office is considering immigration status when they're deciding whether or not to place a person into some sort of alternative custody arrangement, rehabilitation, or some sort of diversion program. And I don't necessarily trust, given what I just said, that they would be doing that. But I do wonder and have a question for you as the Board of Supervisors. Even if you don't have the authority over all of his practices and policies, what authority you have in terms of the $443 million of the budget that they have each year. How are you deciding, knowing that this is a department that is actively allowing ICE to target our community members, how are you deciding what you're going to prioritize funding? Thank you.
Come on. So I am the interpreter, so she's going to speak.
Yes.
Mi nombre es Lidia y vengo por medio de causa justa. Yo considero que cada ser humano merece un trato justo en nuestro sistema legal. Debe de proporcionarle al inmigrante una representación con acceso a asesoría legal y darle a conocer por escrito sus derechos legales, que no está obligado a firmar ningún documento y menos el de ICE. Hearn permitió a los agentes de ICE participar en la exposición militar, militante y racista. Yo considero que al igual es un crimen que las personas que reciben su libertad en Santa Rita, ¿por qué razón salen a las 12, 1 o 2 de la mañana con lluvias, fríos? Tener que caminar hasta la estación del bar es exponerlos al peligro y la muerte, el cual ya se ha dado en varios casos. Ya basta. Y yo pregunto al alguacil, ¿por qué la oficina del alguacil permite a inmigración en las cárceles del condado?
Hello, I am Lydia from Causa Justa, Just Cause. Each human being deserves a just treatment in our system, in our legal system. And we should have every immigrant legal representation. And we should get a written notice about our legal rights and be informed that we don't need to sign any document, especially to ICE. Ahern allowed the ICE authorities to participate in the exposition, in a very racist and militant exposition of our people. And I think that it's a crime that people are getting freed from Santa Rita, at 12:01 a.m. when it's cold and raining in the middle of the night. And they have to walk to the BART station, and they are being exposed to a lot of danger and even death, which has actually happened several times. My question to the sheriff is, why does the sheriff office allows immigration in the jails of the county?
Buenas tardes, mi nombre es Eduarda y vengo de Causa Justa. Y yo estoy muy preocupada porque allá afuera la comunidad está aterrorizada a través de todo el país y San Francisco, Oakland y toda el área de la bahía está asustada. Sus hijos están enfermos de miedo también. Y yo tengo una pregunta para ustedes. La política de la oficina del alguacil es cumplir con las solicitudes de notificación en ciertas situaciones. ¿Quién de la oficina del alguacil es responsable de notificar a ICE? ¿Cuál es el proceso? ¿Con cuánto tiempo de anticipación ICE sabe cuándo se liberará a una persona de la custodia o de la cárcel? Gracias.
My name is Eduarda from Causa Justa, Just Cause. Here the people in the Bay Area is terrorized by what is happening. People in Oakland, San Francisco, in all the area. And also children are being sickened by fear. My question is, the policies of the sheriff's office is to respond to certain notifications in certain cases. Who in the sheriff's office is responsible to notify ICE? What is the process? How long in anticipation does ICE know when will a person be let out from the jail or custody? Thank you.
Sí, buenas tardes. Mi nombre es Gloria Esteva. Trabajo con la comunidad aquí en Oakland y en San Francisco. Bueno, yo hoy estoy aquí porque queremos hacerle preguntas al alguacil. Algunas las va a contestar a su manera. Pero la más fuerte que yo le quiero hacer es, si él sabe hasta qué punto dañan sus actos a las familias y a los niños, en especial a los niños inmigrantes. Estamos viendo, y es muy público y muy notorio, y mucha gente se ha quejado de lo que están haciendo en la frontera. ¿Por qué? Mi pregunta es, ¿por qué repetir esos actos aquí en Oakland? ¿Y por qué también yo les hago la pregunta a ustedes que están aquí en el panel? ¿Por qué como nuestros funcionarios elegidos, como ya se dijo tantas veces, le permiten todo ese poder a un alguacil sobre nuestra comunidad, sobre el dolor de nuestra comunidad y sobre todo sobre el dolor de los niños?
Hello, my name is Gloria Esteva. I work here with the community in Oakland, in the Bay Area, and in San Francisco. And I have a question for the sheriff, and he's going to answer his own way. But the main question that I have is, knowing how harmful his policies are for the families and children in our community, and knowing how harmful there are, what is going on in the borders right now, why here in Oakland do we let those acts happen like they're happening in the border? Why does he allow, and why do our authorities allow that happens to our children and communities? Thank you.
También, pues quiero preguntarles, nosotros hemos venido múltiples de veces a plantearles lo que está sufriendo y viviendo la comunidad. De veras, yo no quiero que me respondan ustedes sobre los actos del alguacil. quisiera que él nos respondiera y que nos respondiera desde su ángulo humano, porque desde el ámbito legal sabemos que hay hoyos y que hay cosas que podemos usar para seguir haciendo daño. Y sobre todo, ¿por qué darle más dinero a una dependencia que está haciendo tanto daño? Esa es mi pregunta a ustedes y por qué ellos piden más. Gracias.
Also, I have been here many times to tell you about the suffering of my community. But I'm not asking you, I'm asking the sheriff. And he's going to respond from his, the way he's going to respond. But I want him to respond from his human side, from his humanity, because we know that the law has holes and sometimes they can't respond to what is fair. But I want to know, why is it that we as community are giving him money or to have these harmful policies against our people?
Bueno, y aquí hubo un señor que no sabía, blanco, que no sabía sus derechos, ¿verdad? Usemos ese dinero para preparar a la comunidad.
Good afternoon, Jackie Gonzalez, formerly Immigration Policy Director at Centro Legal de la Raza, one of many architects of a CLIP. My first point to make is that we're here on a public hearing related to SB 54. We have only been given data for years 2017 and 2016. We know that 86 people have been transferred to immigration custody. We don't know a single thing about who those 86 people are. I'm curious about why data has not been provided in the same manner for this year, given that we're already in September. Presumably the data collected happens for every person at the moment the person is detained or released. I'd like to also know an additional column that would be helpful for the 2018 data would be whether that person was transferred subject to a judicial warrant or one of the criminal exceptions. I can tell you as an attorney who's practiced in this field for a decade, very difficult to determine those criminal exceptions and who should rightfully be transferred over to ICE. So we should have a lot of information on who those 86 people are. And I would ask that this board demand that information. To your point, Supervisor Miley, about what justification there is for cooperating with ICE, I would submit that there is none. Last August, Oakland Police Department cooperated with immigration, and subsequent to the complete disaster of what that incident was, the city council changed their sanctuary policy to close the loophole on any cooperation with immigration, because you know what? We've talked about the sheriff's budget, and while it's large, ICE's budget is much larger. They have their own guns, they have their own personnel. They can effectuate immigration policy in the manner that they choose, and we see what they're doing with it. They don't need anybody's help, much less so a county sheriff's office. Is that my time? Okay. And my last point is just to say that this county has already invested in representation of its people. And it hasn't just invested in a CLIP just to say people should deserve legal services. It said that all Alameda County residents deserve legal services, regardless of their immigration or criminal background. A CLIP is lauded as a national model because we say that everyone is entitled to due process. So we are funding. We could have represented any of those 86 people that were transferred over to immigration because we believe those people are entitled to due process. And the fact that our sheriff disagrees with us on that does not in any way mean that what we should continue to do is to say, well, there's maybe these people out there that have offended in some manner. We've already taken a position because we fund universal representation because that's the dignified thing to do for every resident of Alameda County. Thank you.
Sarah Lee, Reverend Deborah Lee, and Tracy Rosenberg.
Yeah, and I agree with you. That's why when that other person talked about funding for undocumented immigrants, I said to him, we fund everybody so that everybody can get the appropriate defense that's entitled to them by virtue of being in this country. That's what I said. Now, I'm still trying to figure out just what authority the Board of Supervisors would have, and that's why I asked County Council those questions and the attorney from the Resource Center for questions around this matter. But I'm not necessarily going to say that everything, this hearing is good for us to understand and gather data so we can formulate appropriate policy that's going to be effective for everybody. And I'll have more to say once the speakers conclude.
Good afternoon. My name is Sarah Lee. I'm a community organizer with Interfaith Movement for Human Integrity, and we support and work alongside over 40 sanctuary congregations in the Bay Area, and we work here in Oakland. And we are connected to immigrant community members who had been detained at the West County Detention Facility. I wanted to share with you one story of a person who was part of Alameda County and who was detained in West County Detention Facility for over 17 months. He was held overnight at Santa Rita Jail overnight and was charged but not convicted. And the next morning, ICE picked him up. He was held again over 17 months. He was the sole guardian of his daughter who was in middle school in Alameda County. And when it was time for his bond hearing, he was released. But the immigration judge issued a bond that was $80,000. It was based on his pension. And I wanted to share this story today because Alameda County has the opportunity to cut ties with ICE because this is a pipeline that connects the sheriff to the immigration detention to the excessive egregious bond that we saw with his community member. So I think this is the time for Alameda County to stand on the right side of history to cut these ties and not be part of this pipeline. Thanks.
Good afternoon. My name is Reverend Deborah Lee. I'm a pastor of the United Church of Christ, and I'm the executive director of the organization Sarah spoke about, the Interfaith Movement for Human Integrity. We work with faith communities to engage them in issues of immigrant justice and ending mass incarceration. I wanted to just lift up the importance that we see people behind the numbers that we're talking about. The 386 people in 2017, members of our county who were transferred over to ICE or notified over to ICE. And I don't know how you feel about this, but I am there's a pit in my stomach thinking about how many families this has caused destabilization to their families, many of them on the verge of homelessness, thousands of dollars of debt, children who have been traumatized, and many of them who actually have been deported. But even those who are still here and fighting their deportation detention, I think have been completely overwhelmed by this. And so I think that is a huge impact on our larger community. I wanted to address Supervisor Carson. You talked about the reentry community and the immigrant community. And I think these communities are actually not often separate. They're actually often the same, and they overlap. And so what breaks my heart, because I also do work in San Quentin on a regular basis, what breaks my heart is that when people who have been prepared for release, they've been deemed safe for release, they've been granted pardons or clemency, and that then just because of their country of origin, instead of coming home, they're getting deported. And that's what those release dates are doing, is that instead of preparing people for what we have prepared and put a lot of our resources into, the second chance that we believe they deserve, just because of that, they're going to get deported, and even though their whole families may be here in Alameda County. I take issue with how the sheriff characterized the 386. He talked about them as being violent and being felons. I want to say they may have been at some point convicted, but they are not now today. They wouldn't have been getting released if they hadn't completed their sentences or be deemed safe for release. So we don't believe that anybody should carry this category of felon for their whole life. So the fact that ICE is doing that, I think, is a big concern. I want to just say also in response very quickly to Supervisor Miley, I think a quicker way that we could do this to make sure that all of our residents are safe is really for us to convince our sheriff to take the kind of stand that Santa Clara and San Francisco sheriffs have taken, that believe that no collaboration with ICE is the way that we should go, including notifications at all. I think this would be a much easier way than trying to change the legislature, and I think that this is something that reflects the values here. And I hope that we can revisit the issue of publishing release dates. It seems like we can find a way around this. We can talk to the reentry community. We can talk to many others for whom this may be easier for, but if they understood that it meant their neighbors disappearing in the middle of the night, I think that they would be willing to look at some other alternatives so that everybody can be safe and continue to be residents here in this community. Thank you.
Good afternoon, supervisors. Tracy Rosenberg from Oakland Privacy. I want to kind of start off at the beginning and just remind us all that we are sitting in a sanctuary county. It's important to understand that. When Oakland was having its little kerfluffle back in 2017 about an ICE raid, we had a term, and it sounds a bit aggressive, but it's really not. And it was called sanctuary BS, or sanctuary bullshit. And what we meant by it was that it's not just words when you pass these resolutions. There are actions that come with it, and it has to be real. And as immigration enforcement is changing, our definition of sanctuary and what it means also is changing. When it comes to the posting of release dates, both Alameda and Contra Costa started doing so in spring of 2018 after SB 54 came out. And that's had a very specific impact because of that law and because of the way that immigration enforcement is being carried out. So I think it's a little bit disingenuous to go back to 2012. Yes, that all might have happened and that might be how we've gotten here, but this is not the only policy that we have to revisit because the White House has changed, because immigration enforcement has changed, because the conditions are different, and because we are facing something that is not at all like what we were facing in 2012. It's okay to go back and revisit that, and in fact, we absolutely have to do so. And I don't think there's anyone in the reentry community that wouldn't understand that President Trump is a president like we've never had before. Things are just not the same. I go to Sacramento fairly frequently, and for reasons you guys probably understand, talk a bit about the relationship between the legislature and sheriff's departments and law enforcement agencies.
Your time is up.
In general. Oh dear, I'm sorry. But I can just tell you quickly, the chair of the Assembly Public Safety Committee says you guys need to have the power to set policy. Senate Judiciary Council says the same thing. These principles are under discussion, and you shouldn't feel helpless and you shouldn't feel powerless. You are not. Thank you.
Next, we have Lindsay M.A. Hong, Sylvia Moitencia Munoz, Melina Mayorga.
Yes, hi. Lindsay had to leave, unfortunately, but she did leave a statement. May I read it in her time?
Sure.
Yeah. My name is Lindsay Imai Hong, resident of Oakland. I'm sorry I couldn't stay to give my testimony in person. I'm here in my capacity as a member of Hand in Hand, as a descendant of Japanese immigrants who, like what is happening today, were incarcerated because of their nationality during World War II. I'm here most importantly in my capacity as a parent of 2 young children who every night I put them to bed remind me of the children being separated from their parents at the border and here in Alameda County by immigration policies and by practices by the sheriff's office. I think of the terror of the children and the sorrow of their parents. My question is about data, because we do deserve to know how public dollars are being spent, and because it will help us create more just policies. I understand that Sheriff Ahern has denied more than one public records request about their communication with ICE? Will the sheriff commit to collecting and making public its data on its communications with ICE? Thank you. And you also called my name. So I'm Malena Mayorga. I am with Mujeres Unidas y Activas, a Latina immigrant women's organization that serves residents throughout Alameda County, including Union City, Fremont, Hayward, Oakland, many cities throughout the county. We are part of ASILEP, and so I also want to thank the board for the support for this critical work to protect immigrant communities. And yes, we have given a report to the Board of Supervisors, and I think we have another report coming up shortly as well. So we hear firsthand, both at Mujeres Unidas and on the ASILEP hotline, we hear firsthand of the devastation of the sheriff's policies. The family separation is not just happening at the border. We hear, of course, about the terror of children being torn from their parents at the border, but it's happening right here where parents are being torn from their children at the hands of the sheriff. By publishing the release dates, which is a decision that, as many have noted, was made shortly after the California Values Act went into effect, it's clearly an abuse of the loophole in the California Values Act and a violation of the spirit of the sanctuary policies of many cities in the county, as well as the resolution that you yourselves have passed. The Sheriff's Department was able to respond to ICE notifications and use its resources and hundreds of ICE notifications. Why don't instead we use those resources to facilitate communication when people are being released with their families? So the sheriff, as you're well aware, has a budget of $443 million. And so why not use some of those resources to actually facilitate families communicating with their families? Because I absolutely agree that we need to work together with reentry orgs and support. Is that my time? So I just want us to be creative about how we can do both at the same time, supporting people being released from jail and reuniting with their families, and not put people's lives at risk to do that. We can protect people's lives and support them connecting with their families at the same time. Thank you.
Buenas tardes, mi nombre es Hortensia Muñoz. Yo trabajo en la organización de Mujeres Unidas Activas, que está en San Francisco, Oakland, Union City, Fremont y Newark. Como en Mujeres Unidas Activas, mujeres inmigrantes, muchas sobrevivientes de violencia doméstica, asalto sexual, tráfico humano, no tenemos la confianza con el sheriff ni con la policía, por miedo a ser reportadas a inmigración por el racismo y usar del perfil racial, y por la violencia contra las comunidades. Inclusive muchas mujeres tienen miedo a ir al doctor o a reportar algo que está pasando en la comunidad por miedo. Por eso son importantes las políticas de santuario y no colaborar con inmigración de ninguna manera. El sheriff está violando el espíritu de las políticas de santuario del condado de Alameda. Gracias.
Good afternoon. My name is Hortensia Muñoz. I work in Mujeres Unidas Activas. As immigrant women, many survivors of domestic violence in this county, we don't trust that the sheriff, we don't trust the sheriff or the police because we're afraid of being reported to immigration authorities because of the racism and because they use racial profiling and because of the violence against our communities. Actually, many women are afraid to go to the doctor. And that is why it's important that the sanctuary policies be respected and not collaborate with immigration in any way. The sheriff is violating the spirits of the sanctuary policies in the county of Alameda. Thank you.
Is there anybody else I didn't get? Okay, so that's the public speaking comments. Supervisor Valle.
Thank you, Supervisor Chan, for conducting this public forum on the Truth Act. I think we learned a lot today. I want to report to the board, my colleagues, and the public that the Ad Hoc Committee on Immigration continues to meet. We are in the process of hiring somebody to do a final report. That draft will be completed soon. When it is, we will hold 2 more community forums based on all of the hearings that we've had with department heads and people in the community. We will report out to you, seek your feedback, and then bring that input back into a final report that will be brought before the full board with some recommendations. We hope to do that before the end of this year. It's rapidly approaching. I think some of the things that we heard today, we may wrap into that report as well. Thank you.
Supervisor Miley.
Yeah, thank you. Yeah, I really appreciate folks showing up today, and I appreciate the fact that the law requires this type of hearing, because, I mean, there's nothing wrong with transparency, fact-finding, data gathering, information, and an understanding of what's happening, what isn't happening, and of clarification around the law in these various matters. So I do very much value and appreciate all of this today, and that it's required. I do think it would be good when we, Supervisor Vice said the committee will be looking at this, but I also feel that if it doesn't come through the committee, when we hold these hearings, again, I guess it's just once a year, but if it comes through the committee, it might happen sooner. If we could have more information about, for instance, the in this case it was 86, if we can drill down more on that so that we could have more intelligence around that, and then how that data is being shared and used throughout the state in terms of how it's being compiled, so that we can try to understand what's really happening out there among the various law enforcement agencies relative to immigration and working with ICE. I do think, the Sheriff's Department, many people might not be aware of this, and maybe folks are, but the Sheriff's Department isn't just the jail, it's the jail. The Sheriff's Department provides the law enforcement for the unincorporated community, which is, if it were a city, it would be the 4th largest city in the county. Only Oakland, Fremont, and Hayward would be larger. So the unincorporated community, the Sheriff's Department provides law enforcement. I represent a good portion of the unincorporated community. The Sheriff's Department does a very good job with law enforcement in the unincorporated community. So they have that responsibility. They have the responsibility to jail. They have responsibility for contract services. They have a lot of contracts. The Sheriff's Department is very entrepreneurial. And the Sheriff's Department, through the Sheriff, is responsible for disaster and emergency preparedness throughout the region, which stretches far and wide as well. So the Sheriff's Department isn't just the jail, but the jail with immigration, I think, is what we've been focused on today. I would hope, based on what the Sheriff has heard, that the Sheriff would entertain looking at policies and procedures and things that would help to alleviate some of this angst that the undocumented community feels about the Sheriff's Department. I don't necessarily share the opinions and the rhetoric that people have put forth in terms of characterizing the Sheriff and either him personally or his department. I don't necessarily associate myself with those remarks, but I do hope the Sheriff would take under advisement, as one of the clergy pointed out, actions that can be taken, policies and protocols that can be taken to try to alleviate this distrust, this angst, this anxiety. I know when we've talked about this for the unincorporated communities, I've met with the Sheriff, I've met with the Undersheriff, and things have happened in the unincorporated community to help alleviate some of these concerns. I know the Sheriff's Department holds meetings with the Spanish-speaking community, with the Latino community. There's forums that take place, and there's policies that are in practice out there. So I think if we could look at this in the context of the jail, if the Sheriff's Department would take under advisement, meet with your staff, and the Sheriff, and I just want to say this too, the Sheriff doesn't just have white men who are in positions of authority at the Sheriff's Department. He has got people of color who are captains, who are lieutenants, who are sergeants, I don't, that might be the monkey in the room, but I don't want people to think that the Sheriff's Department has a lot of capable men and women of color who are in charge of very responsible things in the Sheriff's Department. So with that collective intelligence, the Sheriff's Department can go forth and the Sheriff can go forth. We're trying to take actions that would help to alleviate some of this, this antagonism that we feel. And I feel that Supervisor Carson hit it on the nose. We got so much antagonism going on in this friggin' country around a lot of different issues. Anything we can do to alleviate and address it, we should be trying to do that. We should be trying to do that. So I would once again encourage the sheriff to do this. Thirdly, folks have asked, why don't we do something with the sheriff's budget? Well, I am not going to hold the sheriff's budget blackmail to trying to do something around immigration. The reason I wouldn't do that is because there are other responsibilities that the sheriff undertakes. As I pointed out, he's got responsibility in the unincorporated community. He's got responsibilities for disaster preparedness and emergency preparedness. He's got responsibilities to work with all segments of our society as well. So I'm not going to impede his ability to carry out the responsibilities of his department by holding his budget hostage. He's got deputies. He's got sworn and unsworn personnel that are required to receive compensation and benefits and also to be assured of their safety as they work either in the jail, patrolling the streets, patrolling the airport, patrolling AC Transit bus lines, doing all the things they do. Those are responsibilities of the Sheriff's Department too. So when people come and tell me, and they've been saying this over and over again, why don't we do something about the budget? I'm going to tell you, you're going to be hard pressed to get me to do something about the budget as long as I understand the sheriff has got responsibilities in other areas as well. But I do think he needs to take steps to try to address your concerns and alleviate this tension and this uncomfortableness. This is not the city of Oakland. This is the county of Alameda. So what the city of Oakland does is the city of Oakland. What the county does is the county of Alameda. We've got 14 cities in the unincorporated area representing about 1.6 million people in this county. And let me think here. So I respect the advocates coming forth, presenting your positions, because I think that's very important for us to understand that and to hear that. And I hope it won't go on our deaf ears, because we need to try to do what we can do, but I hope it doesn't go on deaf ears of the sheriff and his colleagues as well. And let me see if there's anything else I wanted to say here before I finish. I think once again, pardon me? I need to hear more about that. I think the President Chan said that would be coming back to the board at some point this fall. Tomorrow. Okay, so when that comes to the board, I will look at that issue. To determine whether or not I support that or don't support that, or in what configuration I would support that. So I would take that up at that point in time. If it's coming tomorrow, then I'll be taking that matter up when it's here before the Board of Supervisors. So with that being said, I just want to say once again, I do value this information. I think it's informative and it's helpful. And if there are things that can be done without legislation, court-ordered judicial action, Attorney General conversations, if there are things that the sheriff can take upon himself to do, I would encourage the sheriff to do those things.
Anything else? Supervisor Carson.
A couple of questions. What might be the issues taken up or the items taken up that are relative to at least today's discussion at the Immigration Committee?
There's a lot of, I think, information that needs to be discussed with regard to deportation processes at the jail. But one of the things that we heard from the communities in our community forums was the fear that people have of law enforcement. At our very first meeting, we had law enforcement from 4 cities, all 4 police chiefs, 3 out of 4 mayors present, to sort of dispel the notion that the cities were cooperating in any way, shape, or form with ICE, especially with regard to doing raids. There's today's conversation, I think, people are looking for reassurances that the Sheriff's Department is in line with the other chiefs of the county with regard to this policy. So I hope that I know that I visited the jail, and I've seen where the sheriff has shown me where ICE reports to the jail and the areas that they're confined to. And I think the sharing of that information is important to the community, and any assurances that we can get from the sheriff to substantiate and back up his reporting that the department is not cooperating with ICE, but they do have access to information and they do come onto the premises of the jail is relevant. Also important, I think, is the lack of presence that he's seen as the Truth Act has been enacted, I think, is also important.
Which committee would undertake, if there was a revisiting of the policy that this board passed in terms of notification, where does that come up? I don't know.
I think that should go to public safety.
Public safety?
Yeah, the immigration, where we're at is, we were looking at what each of our, it's sort of like the homeless. We're looking at what each county agency does around immigration and trying to see whether it fits together and what kind of plan we can develop. It's also looking at whether the question that Supervisor Miley asked about how successful CLIP has been and whether we want to continue that funding, over the next few years, or are there immigrant groups that we haven't addressed with that funding? We'll be looking at the public charge issue. So I think that issue, I don't know when you can schedule it, but I think this issue of whether we should continue to do the posting in a way that that the reentry community can still access their families should go to public safety. And I don't know when you're having your next meeting.
I think we have a very full agenda in October, but maybe we can look at that in November. I just want to say that, whatever public protection does at our committee comes back to the full board. And that includes the issue that was just raised recently with regard to the audit of the sheriff. We had a forum, we had an overflow crowd that was downstairs while this forum was in repair. And so we had an outcome of that that's going to come forward to the full board on Tuesday. That's tomorrow.
Look forward to that because I think I've said this before. I honestly believe we're living in extremely dangerous times and very divisive times in this community, and not in this just in this community, but in this world. And even though with the formation of the Constitution, which was an imperfect document, and we live in an imperfect union, I think I personally have a responsibility to do as much as I can to try to make some adjustments around the imperfection. The important thing, though, is how we do it in a way that gets results, but maintains, while rightfully so there is anger, rightfully so there is anger, rightfully so there is distrust, rightfully so history shows us that unfortunately a country that's supposed to be welcoming to all individuals is still not welcoming to all individuals, that we have to have those discussions in a way that while it may be personal to everybody, we can't always personalize our attacks that way. I may disagree with the sheriff on more things than anybody else on this board, but I never attack him personally. I think that there always has to be the ability to have conversations, to have dialogue, to have those debates, to find out where we can continue to move towards a more perfect union and a more perfect outcome, especially in Alameda County. And we have to figure out a way to do that, despite the honesty and the anger that people individually feel, that it can't be directed only as a person, but how do we change policy and how do we change the way we provide services to improve those services. I didn't ask you for patience. Not once did I mention patience. I'm going to respect you to respond the way you want to respond. You can do that. I'm not going to argue that point because your experiences are your experiences. I've probably been stopped by the police way more than you've ever been stopped by the police. Yet and still, I don't think that I'm going to jump out of my car and reach for my wallet, which they may think is my gun. And I got to figure out a way that it's not just about me, it's about everybody. So I'm going to respect you on that, right? But I think my responsibility is to constantly figure out how we come to a table to make change. There's always going to be people outside that says, I'm not coming to that table. I'm going to respect that. But my responsibility as an elected official is how do I get to that table to make change? And we can't do it at the table if we're acting like the judge just did in DC, yelling and screaming. We can't get there. And so we got to figure out how we get to that table to make that change. For me, I have to go on record. I don't think I can make change if I'm yelling, screaming, and cussing at the person. That's just me. I'm not saying you did that, right? I got to figure out how we get to a place that we hear each other first, and then figure out how we make that change. So, I think everybody has to be at all the meetings that talk about change, all of them. You can't miss them because, the odds are stacked against us. I'm not that crazy. And so we got to be there and we got to constantly do what you just did today, stay until 5 o'clock to make sure that you're heard. And then we got to continue to move towards change.
Okay, I want to thank all of you for coming, and I think we've got something concrete out of this hearing. We're going to move on, look at this issue of the public posting in the next month or so. Oh, by the way, the audit isn't on the agenda tomorrow. It's on the 9th. Okay, so just to correct that. And, I just agree with my colleagues. This is a very upsetting time, and I think particularly those of us who have common interests, like the reentry community and immigrants, we have to find ways to work together. There are a lot of divisions and a lot of things that are said that pull people apart. And one of the things I appreciated, Supervisor Carson and I met during the Rainbow Coalition period, and people were very successful in working together then, and I think we have to try to find that success again if we're going to beat back some of these right-wing policies that are happening in the country. So I also want to thank the County Administrator's Office and my staff, Vanessa Cedeno, who put the hearing together. It was a lot of work. And for you, all of you for coming out and staying. So look forward to working with you on these issues in the future. So if there's nothing else, is there any speakers on items not on this agenda? Oh, yes.
Just to clarify that there are instances when the sheriff does respond to notification requests. We do have some copies of instances of notification forms as are required under the Truth Act, because the sheriff is required to notify the individual and is required to notify the individual and their defender when the office does notify. So just noting that there are instances where ICE perhaps gets the notification just online, and there are instances where the sheriff himself or
the office does respond to that notification.
I guess I'm missing some of your points. I'm struggling to try to hear
Oh,
them.
pardon.
So it's not on you, it's on me. So you're saying what specifically?
Oh, just clarifying that when ICE sends a notification request or when ICE is trying to get someone's release date, that there are instances, presumably when ICE just gets that information online because it's publicly posted, but there are also instances where the sheriff does appear to affirmatively provide that information because we do have copies of
Yeah, he didn't
forms
deny
indicating.
that.
Oh, okay.
He said
just
they do that.
clarifying. Okay, just clarifying.
Yeah, he said they do that. Okay, we're adjourned. Thank you.